one case in the list, serial number 20. It's an admitted case hearing matter. But I pray that it may be heard on a today or on a date fixed by this.
सर जिस दिन केस टेकअप होगा ना उस दिन आपका जूनियर खड़ा होकर टाइम मांगेगा।
जी
आपका कोई भी केस बिना टाइम के नहीं होता है। आज वैसे भी टेकअप होने की कोई उम्मीद नहीं है।
मेरा एक प्रॉब्लम है कि एग्जीक्यूशन में रिट इशू करने के लिए पैसा वगैरह पुलिस एंड मजिस्ट्रेट के लिए सब जमा कर दिया। If the premises is vacated, then
लैंडलॉर्ड-टेनेंट रिलेशनशिप।
I will.
You are the tenant.
I'm not a tenant, but I have been held to be a tenant. That I have challenged before this honorable court.
Who is Padata sir?
Mr. S.K. sir. I have taken his consent also. Last date was released, लेकिन mention नहीं। Any date will not, but
आज ही करेंगे।
हाँ।
कितने बजे आइएगा जी? 4 बजे आइए। 4 o'clock। Come at 4.
ठीक है ठीक।
Obliged by serial number 32 your lordship admitted matter your lordship जो बोले थे
कि इसको एजेंसी में क्या
ये your lordship उसमें एग्जीक्यूशन केस चल रहा है हुजूर और वो एग्जीक्यूट हो जाएगा हुजूर देयर इज एन आई हुजूर बोले थे कि नोटिस के बाद हम उसको सुन लेंगे admitted by your lordship सेल्फ irreparable injury में इंसू लॉर्ड उनका सूट भी डिसमिस हो गया था अपील भी डिसमिस हो गया जी हुजूर
क्या चीज का सूट
वो जो सूट था वो जो राइट टाइटल इंटरेस्ट का बिल
टाइटल सूट है ना
हाँ दैट वाज डिसमिस्ड वो सूट डिसमिस्ड हो गया था हम उसमें डिफेंडेंट थे दे हैव प्रीफर्ड एन अपील दैट अपील वाज आल्सो डिसमिस्ड बट मॉडिफाइड योर लॉर्डशिप मतलब द ऑर्डर कि जो राइट वो मांगे नहीं थे हुजूर जो रिलीफ वो मांगे नहीं थे वो रिलीफ ऑक्यूपेशनल राइट दे दिया था दैट ऑक्यूपेशनल राइट हुजूर सिर्फ एडमिनिस्ट्रेटिव ऑर्डर से होता था हुजूर
यू आर इन ऑक्यूपेशन ऑफ द प्रॉपर्टी नो
आई एम इन पोजीशन ऑफ द
इज देयर एनी डायरेक्शन टू इविक्ट
योर लॉर्डशिप जब
इज देयर एनी डायरेक्शन टू इविक्ट
योर लॉर्डशिप
द एग्जीक्यूशन क्या चल रहा है
yes that is the question my lord once they are if they are in possession why the execution अगर possession में है तो execution किस लिए
तब एग्जीक्यूशन में जाके एक्सप्लेन करिए ना यहाँ पे क्या करना है
हुजूर वो एग्जीक्यूट हो जाएगा हुजूर माय लॉर्ड हैज एडमिटेड माय योर हरसेल्फ योर लॉर्डशिप उसमें हुजूर आई विल बी इरेपरेबल हुजूर वहां वो कह रहा है कि आई कैन नॉट गो बियॉन्ड
आप अपीलांट है कि रेस्पोंडेंट
हम यहाँ पे अपीलांट है हुजूर वहां पे हम डिफेंडेंट थे फिर वहां पे रेस्पोंडेंट थे
आपके केस में रेस्पोंडेंट कौन है
रेस्पोंडेंट को नोटिस हुआ है हुजूर नोटिस सर्व हो गया बट दे चूजर नॉट टू अपीयर और वहां नीचे कोर्ट में प्रोसीड कर रहे हैं हुजूर एग्जीक्यूशन केस को सो हम लोग
देखते हैं नेक्स्ट वीक करिएगा
हुजूर इसमें हुजूर 25 तारीख को केस रखा गया है हुजूर उसमें हमको बोला गया कि हम इस डेट में हम एग्जीक्यूट कर देंगे बिकॉज़ एग्जीक्यूशन वो जो अपीलेट ऑर्डर है उसको एग्जीक्यूट कर देंगे तो आई विल बी डिस्पोज्ड लॉर्ड अगर उनका अपील भी डिसमिस हो जाता मॉडिफाई कर देता लॉर्ड हमारे पास तो कोई चांस नहीं है हम तो हुजूर को ही बोल सकते हैं अभी एग्जीक्यूशन कोर्ट क्या कहता है कि हम आई कैन नॉट गो बियॉन्ड द डिक्री
आप कुछ ऑर्डर लाए हैं एग्जीक्यूशन का लास्ट ऑर्डर
हां
कहां है
लास्ट ऑर्डर नहीं हम एग्जीक्यूशन का जो ऑर्डर शीट था हुजूर
लास्ट ऑर्डर लिखे लास्ट ऑर्डर डाउनलोड करके लिखे
तो
क्या चीज है सब नेट में है ऑर्डर
एग्जीक्यूशन का नेट पे नहीं है हुजूर
क्यों नहीं होगा
नहीं होता हुजूर वो खुद सिर्फ हाथ से लिखते हैं हुजूर ऑर्डर शीट इसीलिए लॉर्डशिप ने तो आई विल ब्रिंग हुजूर का ऑर्डर हम कैसे नहीं लाते
ऐसे नहीं आप लिख ऐसे नहीं आप सर्टिफाइड कॉपी लिखें ऐसे नहीं करेंगे देखिए मेरे लिए इतना कैपेसिटी मेरे में नहीं है कि ये फर्स्ट अपील सेकंड अपील हम तेजी से कर सकें ठीक है आई टेक माय ऑन
एक डेट
आप 15 मिनट तो मेंशनिंग में बिता देंगे राइट
इरेपरेबल इंजरी हुजूर
ऐसे नहीं आप नेक्स्ट वीक आइए आप ऑर्डर शीट लेके आइए तब फिक्स करेंगे ऐसे नहीं फिक्स
तो हुजूर इसको 24th को रख दीजिए 32
आपके कहने से कुछ नहीं होगा
नेक्स्ट
एंड प्लीज spare us we are in the midst of a hearing matter आप अपना ऑर्डर शीट लेके आके मेंशन करिए हर एक केस का डेट पड़ता है यहाँ पे कोई केस डिलिस्ट नहीं होता
आई जस्ट वांट टू नो कि नेक्स्ट वीक वेयर तो वेदर इट इज रेडी मिलो
आपको कोर्ट का प्रोसीजर नहीं पता है दैट्स योर प्रॉब्लम ओके
From supplementary list and writing code to be mentioned item 1 second appeal 42 of 2023
इसमें कुछ एरर हो गया है
हाँ ये डेट ऑफ सूट
हाँ
That has been wrongly mentioned in the impugned orders
हाँ,
also.
लेकिन ऑफिस ने पॉइंट आउट भी नहीं किया था
Office ने point that should have been pointed out in the
उसको हम भेज सकते हैं रेक्टिफिकेशन के लिए
notification कर दिया आप यहाँ हमारे मेमो में उसको करेक्ट करने के लिए कर दीजिए. That is
उसके लिए आपको आईए फाइल करना
तो
पड़ेगा
डिफेक्ट
पहले
तो डिफेक्ट पॉइंट आउट होता तो हो जाता. डिफेक्ट नहीं पॉइंट आउट किया इसलिए ना किया. वो हमको अलाउ कर दीजिए डिफेक्ट.
फर्स्ट लेट इट बी रेक्टिफाई
यस.
सिर्फ उसी में नहीं करना पड़ेगा हमको अपने जजमेंट में भी करना पड़ेगा
हाँ एक्चुअली वो
ठीक है.
impugned ऑर्डर भी नहीं है. वहाँ तो जितने impugned ऑर्डर का अपीलेट कोर्ट का है.
जो भी है वो एरर है सो तो कुछ कर नहीं सकते ना. Essay number 42 of 2023. This case has been listed at the instance of the office. It has been disposed of by judgment dated 22nd of April 2025. The office note reveals that on perusal of case record, the case number mentioned in title suit number, the case number is mentioned as title suit number 76 of 2001 and also title suit number 76 of 2013 in the trial court judgment. Case number in the trial court decree is mentioned as title suit number 76 of 2013. Office is directed to send back the trial court judgment for necessary correction by the court concerned. The matter be posted immediately on receipt of the corrected one.
Underwriting for final disposal fixed rate, item 5, SA 15 of 2025.
Only paying for short passover. He is appearing before Honorable DB1. He'll be only for 1 or 2 cases.
No, we will not pass it. You continue with it. You continue with it. Sorry?
File the brief as with him.
He is sitting with the brief in court number 1. You going to say that? Yes?
Sure. I could not take the brief from him. Inside he will be
I am absolutely clueless.
one for one case.
You see, the procedure is whenever there is a part-heard matter has to be given preference with respect to any other matter in any other bench. If there is except when there is a constitutional bench. That is the procedure of our court, and I think that is the procedure everywhere. Correct?
I can give you the file.
Tell
Okay,
me.
the entire certified copy,
Okay.
whatever he wants to read.
Yes, please.
Lordship had confined the appeal to 2 points. One on the Safia Khatun and second on Hima. So he has to show from the evidences.
No, if you have got some other point, you can certainly
Yes,
say.
that he is free.
These are the two major points.
Your Lordship, one point which I had seen yesterday, Your Lordship, there was submission that partial partition is not allowed. Because there were, it is an admitted fact, and the parties have admitted this, that there were other properties of Abdul Ghani, which was mentioned, but it was not made subject matter of the partitions. On this, there was a submission that partial partition under Muslim law is allowed. Your Lordship, I have few judgments, and that part will be placed before Your
No, I
Lordship.
just want to know, did you raise any objection with regard to partial partition?
Your Lordship, after filing of WS, we filed for a petition for amendment raising this objection. That petition was rejected. Subsequently, we filed a CMP before Your Ladyship here. Before passing any order in CMP, Your Ladyship, the final judgment was passed. So eventually, we had to withdraw that case.
Fair enough.
So, but it is, and your leadership, there are other judgments which say once it's admitted, it was the duty upon the court to add those properties. So that part also, I'll come with a judgment to
You
that.
see, the point is that you did not raise any specific objection. We'll take care of that, subject to what the other side has to say. What is the date of your amendment, petition seeking amendment?
There is an order to that effect by the trial court. I'll just show you. The order is dated 9th of September 2022. So they moved the application in and around the same period, petition, by which the learned trial court was pleased to dismiss their amendment application on the grounds that property which we are talking about is in Bihar. We will change the nature of the suit, and further they filed basically a CMP also before this honorable court. No order was basically obtained by them, which ultimately they withdrew. So one of the arguments will that attain finality, but in any case, even if they take this plea,
What was the CMP number?
CMP number was 821 of 2022.
This entire order should be done. 841 of 22.
I have just got the order. I'll give it. Just I have got put.
It was withdrawn. Was it withdrawn?
It was withdrawn. It was withdrawn.
On
It was withdrawn
10th
as
of December 2024.
10, 12, 24. And when was it?
they
filed?
approached for amendment on 29th of August 2022. Volume 3, page 84-85, that petition is there before this court in the trial court record. And the order was passed on 9th of September 2022. They filed a CMP number 821-2022, which was withdrawn. Ultimately, no order was passed. Divorce that, there will be a legal argument of that if it is raised by the other side.
That's it. They are raising it, you will have your response.
Yes, sir. I'll have the response. The judgments are there in the compilation.
So, this is additionally you want to raise the point that there cannot be a partial partition with respect to suit clause. Okay. What else? So, 3 points now. Hiba, whether proved or not. Second, non-joinder of necessary party with respect to one Khatun,
Safia
Khatun. There is no other person with regard to non-joinder of party. And the third is there cannot be partial partition. Right? These 3 points are determined.
This is the order of CM.
Yes, please continue.
Instead of stating the facts, I take the notice to the judgment notice takes care of it selectively, not the entire judgment. So I will skip the repetitive part now. So we kindly come to the judgment. Because I was reading only yesterday what
It has been read full text.
to the extent I have been able to notes prepare, I will assist you notes. Note the judgment starts from page 21 of the appeal notes.
You can refer to internal page of the judgment.
Internal
Because
page.
the pages may not
five.
tell.
Internal page 5 of the judgment. The page start with the caption judgment.
Yes.
The case of the plaintiff's para 2, and the state is that parties that is plaintiffs and defendants are under and governed by a civil section of Muslim law. The judge Sheikh Abdul Ghani was a commoner in section of plaintiffs, principal defendant number 1, and defendant number 2 to 6, and performer defendant number 7 to 11. That Sheikh Abdul Ghani, the common ancestor of the parties, predeceased, and his wife, Srimati Fatima Khatun, also deceased, leaving behind their 4 sons. So there is no dispute that there are 4 sons and 5 daughters. One of the daughters not predeceased. So there is not 4 plus 4. 4 sons, Mahmud Alam, Mohit Alam, plaintiff number 2, Wali Alam, defendant number 1, and Jafar Alam, Saint Aziz, and 5 daughters, namely Srimati Noor Jahan Khatun, defendant number 2, Srimati Karima Khatun, defendant number 6, Srimati Jayadun Nisa, Safia Khatun, Saint Aziz, and Razia Khatun, Saint Aziz, as their legal heirs and successors with respect to his all movable and legal properties in the estate of the Saint Aziz, Sheikh Abdul Ghani. Jafar Alam expired, leaving behind his 2 sons, namely Hassan Rizvi, alias so and 1 daughter, Isra, and widow Abima Khatun, as a legal heir. That as Safia Khatun predeceased her father, Sheikh Abdul Ghani, hence she has been disowned and abolished from her rights of inheritance with respect to estate of property of the father. Sheikh Abdul Ghani, as per Muslim law and Sharia, and hence the heirs who are not entitled for any share over the property of Sheikh Abdul Ghani, has not been made parties to this suit. There are to be citations are there, there are to be facts have been related as to who or what died when and what. Therefore, basically, what Sheikh Abdul Ghani, as per the partition laws, the London law, it is 2:1. Whatever they say the females will get, it is double that what the sons will get. The sons and daughters. So not four sons and there are 4 daughters. So therefore 4 plus 4, 8 not is therefore if it is 4 into 2 is 8 and 8 plus 4 is 12. So therefore 1 by 12 the daughters will get and 2 by 12 the sons will get. That is not the ratio in this note. It is a pre-decided and predetermined ratio. This ratio is not predetermined. It is not what's determined or adjudicated upon the filing of a suit. So this therefore it is not refer to the question of law on the issue. Then what it says that the property was acquired not by between notes Abdul Ghani, Sayyid Muhammad, Ikram Ahmad, and Manazul Hal, and then Abdul Bari mutually and amicably partitioned their above land by means of a deed of partition, and portion of the share of Schedule D land, area measuring 1.5 because of the said deed of partition, dated 5/153 has come in exclusive share, and portion of the deceased Sheikh Abdul Ghani. But between them, other persons, they had partitioned the property, so a bigger one. 1.5 because is the concern of the suit property. That note is find in the next page, para 2. The property was purchased and thereafter it was partitioned and Sheikh Abdul Ghani, the ancestor of the plaintiff, has not in 1.5 because, which is a scheduled property, for which the partition has been sought. Sheikh Abdul Ghani, who during his lifetime had been the absolute and lawful owner in possession of the above land by constructing Pakka house over the eastern portion of the above land, had been enjoying its all acts of ownership with all legal right, title, interest. Then what it said in paragraph 3 of the next page notes, in service settlement of the year 64, they said plot number 5 of the above land converted to plot number so and so and published on 10th day of August 1979. The share and portion of the land of 1.5 because land has been covered to plot number 2 and so and so and so. This is mostly described in Schedule B. Sheikh Abdul Ghani, the common ancestor of the party in the suit, expired on 2381. I'll listen to the last paragraph. So, when the survey law was published not in 1979, the ancestor Sheikh Abdul Ghani was alive. And his wife Srimati Devi Fatima Khatun also expired in the year 1997. After the death of Abdul Ghani, all parties, plaintiffs, principal defendants, and proforma defendants have jointly inherited, acquired, possessed, a Schedule B below property of the deceased Sheikh Abdul Ghani and have been in joint peaceful possession over the same and have been jointly enjoying their all acts of ownership jointly over their respective undivided share in portion with their legal rights, patents. Then what in the next place, what to find second paragraph. That there are unity and joint possession of the parties to the suit over the Schedule B property, and all the parties to the suit are having their respective undivided share in portion over the Schedule B suit property as per Muslim law and Sharia, which has still not been partitioned in between the parties to the suit by means and law. That the principal defendant or one, at least not third paragraph of the page. That the principal defendant number 1 is in occupation of the scheduled issued property, who has been allowed by the other parties to the suit to take, use and occupation of the scheduled issued property, but when it has become inconvenient to the plaintiffs and to whom are defendant, the plaintiffs since last 1 year have been regularly approaching to the defendants, particularly two principal defendants for the partition and demarcation of the respective share and portion of the scheduled issued property, but principal defendant number 1 took time by some of the other critics and did not agree. Then what they came to know in 2014, it is alleged that there was a development agreement with respect to the said property, and then notes and then what the suit came to be filed in 2014. And then the plaintiff said that defendant number 1 has fraudulent, seriously and fraudulently using some false and manufactured documents and could be able to get recorded the entire scheduled issued land in his name in the rights or records of the government of Jharkhand. This is the case note of the plaintiff. Then not to kindly come to Lord's internal phase 8 of the judgment. Last paragraph, paragraph 3. On the basis of the aforesaid pleading, following reliefs are prayed by the plaintiffs. For a decree in favor of the plaintiffs and against the principal defendant number 1, declaring that the plaintiffs are having title and possession over their 6/12 share over the scheduled B suit property. For a plenary decree of plaintiff 6/12 share, that is half share in the scheduled B suit property. For a decree for declaration that scheduled B suit property has not yet been partitioned by metes and bounds as per Muslim law and Sharia among the joint owners of the property to be sued, which has been inherited, acquired and possessed jointly by the heirs and successors of the deceased Sheikh Abdul Ghani, the parties to the suit. For a decree for appointment of a certain insurance for suit. Therefore, he is saying that what a decree of partition for the scheduled B property. Now, they also acknowledge in the plaint that it is in occupation of the defendant number 1. So, admittedly, the plaintiffs are not living there and not in occupation of the suit premises. Now, they are disputing what the entries made in the service settlement of 1974 and 79, saying that it was based upon a khapiyan and therefore the oral date what is being disputed.
Those entries are not subject matter of challenge.
It's not my subject matter. And the entries made in the service settlement under section 84 of the Lord's Supernatural Tenancy Act has the presumption in law. Lord's. Until the contrary is proved, it is entry is proved to be in the name of defendant. Now, what they say that this is a suit property, it has not been partitioned, and I am asking for a partition of the suit, and we are in joint possession and ownership of the suit property.
Joint possession is constructive possession only because admittedly they were not living on the property.
Living on the property. Now, on the face of the defense, that it was by a oral gift given to us, and we have been in occupation. So there was something more than that specific possession law has to be shown. That is not my submission, first submission. Because this specific case of the defendant that it is by oral gift was given to me. Now let us proceed further in the judgment.
So in order to claim exclusive right over the property, defendant number 1 has raised a specific plea that he is the owner of the property by virtue of oral gift.
Oral gift. Given to them.
Otherwise, in absence of oral gift, let us forget
it is
that
within
it's
the
a
joint
joint
possession.
family.
Joint possession. There is no issue of not being a joint possession.
Yes.
Now, Lord, in the Mohammedan law, I will be referring to Lord's Faizi's Lord's commentary.
I hope you have got photocopy for us because we do not know whether we have a
I will not just read it and give it to a Lordship, then I will give a photocopy of the pages, the relevant pages.
We'll get the photocopy done right away.
Yes.
You are referring to which book?
Faizi. Outlines of Mohammedan law.
F-A-I-Z-I.
Asaf A-A-F-Y-Z-E-E.
A-A.
Asaf A-A FIZ, FIZ. These are authoritative notes on the Mohammedan law principles. These are the Mullah's notes. Paragraphs in the Mullah's notes, textbook note is quoted as a section in the judgments,
That's
taking it as an authoritative note.
that's
Same notes will not be the FIZs also. Defendant's case note starts from page 10.
you were referring to the book.
Yes.
See, there are two ways to look at it. First, the basic ingredients for an oral gift, and then you can refer to the reference.
I am only referring to the context where I will be reading not these oral gifts. I will refer to the books and the principles of oral gift and not the evidence. Then not the issue of partial notes partition, which is impermissible in Mohammedan law. The point has been taken or not, the plaintiff has to stand on his own legs. And when he says that this is not the only suit property, and he is asking for only a partition of a particular suit property, at the same time claiming that there are other properties, then it is not permissible. The plaintiff has to be thrown at the threshold at that stage itself. It is not, let us say the defendant does not say anything. It is the plaintiff's stand and the evidence which will decide whether he has strong legs to not support his case. That is what I am saying. So therefore, bro, these two issues not I will be referring to time and again, brothers, interchangeably. But let us not proceed in the judgment how it has proceeded and how it has confused not the Hindu law vis-a-vis the Mohammedan law. Defendant's case starts from page 10 to internal page 10 of the judgment. Paragraph. Defendant case. Principal defendant number 1 in his written statement submitted that the suit is not maintainable in its present form and for the relief's claim. There is no cause of action or right to bring the suit. The suit is barred by limitations of the suit. It is also barred under the provisions of Mohammedan law and Partitions Act. The plaintiff has not been properly signed, verified, and affidavit as required under the law, and on that score alone, the suit is liable to be dismissed. It is further submitted that the suit is bad for non-jointer and misjointer witnesses parties. The widow of late Jafar Alam and sons and daughters of Safiya Khatun are necessary parties in the suit. The logical table is given in student A of the plaintiff is fully correct. Description of the suit land as given in student B of the plaintiff are vague, confusing, and incorrect. The plaintiff is not filed given any comparative. But I am skipping this note because it is relates to the non-jointer parties. Safiya Khatun notes towards the middle. Matter of fact, Safiya Khatun died leaving behind 6 sons, namely Javed Akhtar, Parvez Akhtar, Firoz, Rasheed, Sahid Akhtar, and Sajid Akhtar, and daughters Sama Parveen as her legal heirs and possessors. I will be notes leaving this. Let me come to the next page. Page 12. Here is note internal page 12 of the judgment. Now some notes, 7-8 lines notes from the top. Sheikh Abdul Ghani, the father of the answering defendant, got 1.5 acres of land in his share. That's about this. In the said portion and partition, and he became the owner of the said 1.5 acres. I am not skipping the other 6 acres because it's not concerning the suit. Said Abdul Ghani, while he was in possession of the 1.5 acres of land, the survey operation commenced. And the said survey finally published in 1964. The aforesaid land which was in possession of Sheikh Abdul Ghani came to be recorded in plot number so and so in the name of Abdul Ghani. The aforesaid Sheikh Abdul Ghani, the father of the answering defendant, who was in possession of the aforesaid land, who was in possession of the aforesaid land recorded in plot number so and so, Moza Mango area, measuring more and less 1.5 acres, orally gifted the same in the year 1967 in favor of the answering defendant in presence of the witnesses. That Abdul Ghani, father of the answering defendant, made an unequivocal declaration of his intention of making oral gift of the said land as donor in presence of the witnesses in favor of the answering defendant as donor, who expressed his acceptance of gift in presence of witnesses. The declaration and acceptance of gift was accompanied by delivery of question of the gift by the donor to the donee the answering defendant. The gift became complete in compliance with the aforesaid requirement of gift. Since the aforesaid oral gift made by Sheikh Abdul Ghani, the answering defendant came in full possession of the aforesaid plots of land, measuring 1.5 acres as absolute owner thereof, and also constructed house in the portion of the aforesaid land. That the answering defendant while in possession of the aforesaid land, the present service settlement operation was commenced. In and about year 1971, the present service settlement operation, the aforesaid land, recorded so and so, and the structures standing thereon recorded in the name of answering defendant in the finally published record of rights in the year 1979. Further, it has been submitted that answering defendant is in peaceful possession of this property as absolute owner thereof, and the answering defendant also got his name located in the office of Superior Landlord by Mutation Case number 8788 with respect to the suit land, and is paying rent on the charges and other services. Therefore, notice it came to be recorded in the name of defendant number 1 in the service settlement of 1979, and mutation was also effected. And from the facts stated here in above, it is crystal the answering defendant is the absolute owner of the suit property and is in possession of the same. Plaintiff or the other legal heirs and successors have no manner of right title in case of possession of the suit property or any portion thereof at any point of time, since the aforesaid transfer made in favor of the answering defendant. But the statement made in para 11 of the plaintiff is substantially correct. The statement made in para 12 of the plaintiff is denied after the death of Sheikh Abdul Ghani. Plaintiff, principal defendant, defendants, and former defendants have jointly inherited acquired and possessed civil property over disease. Abdul Ghani and have been in joint peaceful possession over the same, have been jointly enjoying their all acts of ownership, jointly over their respective individual shares and portions with their own legal rights. And that time is there, they have no right title or interest over the suit property. At the submitted above, Sheikh Abdul Ghani during his lifetime in the year 1967 orally gifted the suit land to the answering defendant in presence of the witnesses as stated above. It is also within the knowledge of the plaintiffs and other legal heirs and successors of said Sheikh Abdul Ghani, and since then the answering defendant came in peaceful possession of the suit land and constructed house in a portion of the suit land in living with his family members. Now let us pause here for a moment. Let's come to the what's Mohammedan law vis-a-vis what the Hindu law, so far as gift is concerned. Now, note for general note terms of a gift. Gift note is something which is a transfer of property without any consideration. That is for sure. Now, therefore, note section 123 of the Transfer of Property Act says that any immovable property, if it is to be gifted, has to be through a registered instrument. Now, there is an exception with regard to the Mohammedan law, section 129. There it says that note the under the Mohammedan law, oral gift is permissible. Oral gift note doesn't require any registration, and even a deed of instrument which records an oral gift made does not require a registration. Even if the deed of note of instrument of gift which records an oral gift given earlier is contemporaneous with the transfer of title or ownership or possession, then also it doesn't require registration.
That is hiba nama.
Hiba.
Hiba-nama.
Hiba-nama is a note's instrument of gift. So that instrument of gift not only records, it is an evidence for the purpose to show that oral gift has been made. It is therefore it doesn't require a registration. Even if it not, there was a judgment there which said that if it is contemporaneous, then it requires a registration under section 123. Supreme Court says no, because Mohammedan law permits an oral gift. What are the principles of an oral gift? Oral gift not merely has three principles. Three essentials of a gift are declaration of the gift by the donor, that is ijab, acceptance of the gift by the donee, that is qubul, delivery of possession, that is qabda. These are the three notes essential conditions of an oral gift under the Mohammedan law. That is the manifestation of the wish to give on the part of the donor, the acceptance of the donee either impliedly or expressly, the taking possession of the subject matter of the gift by the donee either actually or constructively. So even if it is constructive, actual, like not in case of a husband and wife. If a husband gives not a gift in favor of wife, then the husband necessarily doesn't want, but cannot go out of the property. because he lives with the wife. Therefore, the wife's possession is constructive as an owner subsequent to the gift. This is the principles note that constructive possession also, even if they are occupying a living concurrently.
Is it to be simultaneous, all the three? Or it can be there can be some gap?
Or it has to be simultaneous.
All the
intention has to be expressed.
All the three?
All the three. Three conditions. When the oral gift is made, that I am intention, my intention.
Simultaneous means at the same point of time.
Same point of time.
When they are saying that it is 1967, there has to be a declaration in 67 on the same day, whatever be the day, acceptance simultaneously, and delivery also simultaneously.
Name note is not relevant for the purpose of, in this case, there is no date mentioned. The only
No,
year is mentioned,
in
1967.
principle, in
Yes.
principle,
That this
can the
such year-
delivery be deferred?
No.
It has to be
It has to be
simultaneous.
simultaneous because not the donor has to part away with the property. Mohammedan law says that he has to part away with the property.
All three ingredients has to be
Simultaneous. So the property is in possession of the plaintiff, is not in the possession of the plaintiff, it was in possession of the defendant because they were living with the father.
That's right.
It was a constructive possession at that time and subsequently not. It was mutated,
Constructive turned out to be exclusive.
exclusive. After the survey settlement recorded their name and the mutation also done not in their name.
This is just a moment. Constructive possession
Culminating
became
into
exclusive possession, right?
with the declaration of the word that mutation has been done in the name of the defendant and the survey settlement also
So
records.
therefore, the question assumes relevance because of the reason that whatever evidence is coming, documentary, it is much after 67. It is much after 67.
No, recording of notes survey settlement is one aspect. It is a notes document to show that possession. Then the mutation, subsequent mutation in 1989 or sometime. It also is a document, collateral document to show possession. But the factum of notes living together from 67 with the father is not disputed. That I have not been living with the notes. The defendant number one is not with the father. He is living with the property in the property, and the defendants have specifically aware that they have constructed the house over that property
You see,
after the gift notes.
after the gift, the donor, he moved out of the property.
No,
He stayed
he
with him.
said, no, he was the father of the not defendant number one.
Yes. He stayed
He
with
stayed
him.
with the not sons. He gifted the property,
That's
and then the not sons not developed the property by constructing the house and continued with it. Then the survey settlement was going on, and then thereafter notes. The 67 is relevant because
When
of
did
the
he
fact.
construct the house?
But it is actually
When did he construct the house?
I will refer to the written statement. That is given in the written statement. These are the not developments meant in the written statement. And
We'll see that. Yeah, it is statement.
Lordship could have a copy of the book which is giving the copy, sir.
ये किताब मंगाई है ना?
Reference.
ये किताब मंगाई
This
है, उसको
particular
दीजिए।
page, entire section of with regard to the gift and gift with conditions not to take a photo.
It is statement.
And this is settled principle of law note accepted by the Supreme Court note in the Katina of judgments. Now this particular book has also been quoted with approval, and the three principles of oral gift note has been acknowledged and has been not quoted with approval not in the Katina of judgments. I will be referring to the judgments also.
निकालिए डिफरेंट नंबर 1 का written statement.
Photo करा दे page number 218 से.
I've got that. Okay. So what is the date of construction?
नहीं दिया. Paragraph 44 note I am reading.
Yes.
That as submitted above, Sheikh Abdul Ghani during his lifetime in the year 1967 orally gifted the suit land to Wali Aam, the father of the answering defendant in presence of the witnesses as stated above. He is also within the knowledge of the plaintiffs and other legal heirs and successors of Sheikh Abdul Ghani. And since then, Wali Alam came in peaceful possession of the suit land and constructed a house in a portion of the suit land and living with his family members. No, the year of the construction is not given. It is also recorded in the judgment also.
So may I just clarify one fact, my learned friend might point out from the evidence also. Is it their case that in 1967, after the Hiba, he came into possession?
He says that he was already in physical possession,
Means he was staying,
but he was staying and he was with the property.
so it was a constructed one.
But I would request my friend to take all my wrong submissions, note it down,
No,
and
yes,
reply
sir.
notes at
Yes,
the end
yes.
of what I say.
Certainly will
I
take.
think
I think notes.
very unnecessary.
Yes. So instead of notes interjecting every now and then, notes breaks the
So
note flow of the
therefore,
counsel as
in
well
a
as the judge.
case where a constructive possession is getting translated into exclusive possession, it becomes all the more important to prove the oral declaration and acceptance.
Oral declaration what is to be proved because it is an oral gift. Oral gift is like this.
How do
notes-
you need to also address that? So your case is constructive translated into.
During that period, note 67, 68, note the service settlement is started. 1971 it
71 is started.
71 is started, notes commented in 79 final publication, where my name is to recorded, but it was with open note. And then kindly note, during that time the father, note the donor is present, he is alive.
That's right.
I cannot not put any title or claim any title against the owner in his presence and during his lifetime, if he is objecting to it.
CNT Act.
So इसका खाली करवा लेने से how gifts are made incidents.
So through the record of rights finally published,
273.
your possession was confirmed.
Confirmed. It was continuous and subsequently confirmed to the exclusion of others. 218 to 273. Page number 218 to 273. Now this also deals with not how what is a constructive possession and everything not I will explain in the 5 notes judgment. Now let us not may I proceed with the judgment.
Yes.
Living with the family that in the year 71 this present survey operation commenced and in the present survey settlement which was finally published in the year 79 and suit land is recorded in the name of the answering defendant. The answering defendant also gave his name indicated in the office of superior landlord as stated above and his pen name. Answering defendant also entered his name in the record of Malwa Notified Area Committee and also paying holding tax with respect to the suit property in his name. That neither the plaintiffs nor the other defendants and the heirs of late Sheikh Abdul Ghani ever raised any objection before the survey authority or in the notified area committee or other authorities claiming any manner of interest over the suit land. Particularly in context where the partition deed specifically gives it to Sheikh Abdul Ghani. It was a purchased property of 6 bigha. 1.5 bighas only belonged to him. That note subsequently was surveyed, settlement and entry was made in name of defendant in the lifetime of Sheikh Abdul Ghani. That is very relevant. Now, let's kindly see. I am not speaking thereafter, not skipping. Other facts are mentioned. Defend number 2 and another thing. Kindly thereafter come to notes, internal page 19. Issues were framed. after the death of person. The basis of the rival pleadings on dated 29/1/2020, altogether 10 issues were framed, which is as follows. Suit is maintainable as claimed. Has the plaintiff got valid cause of action for the suit? Whether the suit is barred by the limitation? Is the suit barred by principles of estoppel, waiver, and acquiescence? Whether the suit is barred for non-joinder and mis-joinder of received parties? Whether the suit is barred under the provisions of Mohammedan Law and Partition Act? This is very relevant note, which takes note of the issue whether the plaintiff will stand on his legs. Whether there is note on the face of the evidence that he gives. Whether the suit is barred under the provisions of Mohammedan Law and Partition Act. Whether there is unity of title and possession between the plaintiff and defendants with regard to the suit property discharged and suitability of the claim. Now, this note is very incorrect because there is no unity of title and possession in case of Mohammedan Law. But when they are claiming a partition, it is unity of possession. It is not a jointness of not title. It is a tenancy in common, not in jointness. This itself note was a incorrectly framed note. Then kindly see para 7. In support of the case, plaintiffs altogether have examined 3 witnesses. PW1 is Mahfouz Alam, who is the plaintiff Lord himself, who is the son of one of the Lord's son of Sheikh Abdul Ghani. PW2 is Sakil Ahmad, and PW3 Muhammad Khalid Azad Hassan. And note thereafter, what we have said, in support of the pleading, the defendants have examined 4 witnesses. Then the documents have been referred to, note the sale deed and note the identification case and note survey settlements. These are not in dispute notes. Then note kindly see page 37, which is very relevant note, internal page 21 of the judgment. PW1. PW1 Muhammad Mahfouz Alam has stated in the line of pleading and supported his case. In his cross-examination, he deposed. Note, these are very crucial. Note, I will straight away go to the plaintiff and then to the plots, evidence of PW1 and PW2. PW1 Muhammad Mahfouz Alam has stated in the line of pleading and supported his case. In his cross-examination, he deposed that Mahfouz Alam died in the month of November 2016. Abdul Ghani was residing at Bhojpur district, Nalanda, where his agricultural land and house was situated. At the time of his death, about 12 to 13 bighas lands were left. And you see, note, these are very pertinent note issues. He is the own evidence of the plaintiff. Earlier, he had about 70 to 80 bighas of land, and some land was sold by his son. Further, he deposed that Muhammad Alam, Moin Alam, Jabbar Alam, all sons of Sheikh Abdul Ghani, had sold the land but cannot say in which year and on what consideration amount they sold the land. Further, he deposed that he cannot say whether the Jafar Alam and Mahmood Alam had also sold the land separately or not. He has no knowledge about how much land of Abdul Ghani is left. But Abdul Ghani house was in the village. Further, he deposed that after the death of Abdul Ghani, his legal heirs and successors are residing at his house. Some part of the house is left. He has no knowledge about that his father Muhammad Nur Alam and his Jabbar Alam and Moin Alam had sold land separately or not. He is residing at Jawahar Nagar, road number 3. Abdul Ghani purchased his land in the year 1999 from Daru Ghosh. And in this land, his 2.5 story house is there, but don't remember from whom he bought the land. Further, he deposed that the aforesaid land is situated Mother so and so, but he cannot say in whose name Khakiyan is recorded. Then what it refers to other what this particular suit land. Then he says Moin Alam has 2 sons, namely Sakil and Samim. Both are residing at Kapali, but both are living separately. Moin Alam has also 5 daughters, all are married. At present, no one takes care of land in village. Further, he is consistently saying that there is a land in village. Some portion of the house is still left. 12 to 13 bighas of land was still left, not when Abdul Ghani died. And further, he deposed Muhammad Alam has 3 sons. Jafar Alam had 2 sons and 1 daughter. Both sons are daughter residing at Jamshedpur. Jafar Alam has own house, but he cannot say from whose he purchased the land. Maybe Jafar Alam and Moin Alam had purchased the land from Shakaldeep Thakur, Razia Khatun, so and so. And her husband has also died, so and so. Further, he deposed that in the year 64, survey was done at Bango area, and according to survey, it was held in the year 64. Plot number was mentioned, and regarding the said plot, this space is filed, and area of the plot is about 50 katta. Further, he deposed that he has no knowledge about what and when the registration of part number was registered in Mango. As per the father's conception plan was prepared, but he has no knowledge about the Schedule B property. Further, he deposed that he has no knowledge about that when survey settlement was held at Mango area, but in his affidavit he has mentioned the Schedule B, Mango, Thana, so and so respectively. He has no knowledge about the recent survey, but he knows that survey was done after 1964. In affidavit, the quantity of land is mentioned, so and so, so and so. Abdul Ghani died, and in this regard, death certificate was submitted in the court at time of death of Abdul Ghani. He has no knowledge what was his movable property. Movable property was in his village for cultivation, but he has no knowledge about how much movable property was there. There was a big house in the village, but he cannot say the area of the said house. Abdul Ghani used to do farming in the village land. On that time, he was not residing at village, and at the death of Abdul Ghani, he and his father were not present at village. He has no knowledge about in how much land his father used to do farming. At the time of Abdul Ghani's death, his son Muhammad Alam and Zafar Alam were in the village, and after the death of Abdul Ghani, his sons used to cultivate the land. It has been divided so that his heirs remain in the village. Further, he deposed that details of property of Abdul Ghani situated in village is not given in this case. He has no knowledge how much land was sold by the sons of Abdul Ghani. Abdul Ghani's property has not been divided. He is saying this. On disputed land, there was a house, but on that time, plan was taken of not. He cannot say he has no knowledge about that. In disputed land at the time of construction of boundary, government had filed the case. He has knowledge about the written statement 5 dependents. Abdul Ghani had 4 sons and 5 daughters. He has no knowledge whether daughters got their share or not. There is no partition in between them. He cannot say how much land had been sold of Abdul Ghani, by whom and which land was sold. He cannot say. Further, he deposed that the village land was partitioned in which sons had 8 shares, whereas daughters had 4 shares. He has no knowledge when service settlement and final publication were made. Now, kindly notes come to the statement notes. He extends so in the note of the plaintiff. PW1.
He says that the village land was partitioned.
He says that there was no partition at one place.
But it is
Then it's
conflict.
among the conflicting. Then
Actually,
he says it was
what has
partition and it was
What
under
has happened-
cultivation. He says it was under cultivation by the party.
What has happened is that if the parties do not raise a point, raising an objection with regard to partial partition, and straight away if the witnesses comes and depose that there are properties in village home, then under such circumstances how, and there is also contradiction in his evidence.
There is contradiction to the extent that what the parties
So
were decided.
can
It was all constructive possession.
Can
All
a
parties were
court
cultivating the
enter
land.
into the point as to whether the partial partition was permissible or not when the defendants had not raised such an issue?
I will come to that. Therefore, defendants have not said anything up till now. It is a plaintiff who is saying that there is a property in the village.
And he does not plaintiff.
Appellate respond.
No, plaintiff is saying.
Plaintiff witness is saying that
Plaintiff
there was a
PW1.
property.
PW1 is saying that there is
saying
landed property and it was still left. So it was because of still left at time of death of Abdul Ghani.
further he's also saying that there was partition.
No, but he kindly see that he has no knowledge about the partition. That is also he says that. And
Yes.
the property still
So
remains in the village.
So therefore,
There is
his evidence is not consistent on the point of existence
But
of
it
property.
is not an Hindu partition. That I choose to partition this and then I leave aside the other properties to be partitioned later on. It will be in jointness and only this much property will be partitioned. If partition happens, it has to be all the property, and no one property can be partitioned by keeping other properties separately. So they cannot be partitioned. When he says that the parties are living and they, when was the death? Death of Abdul Ghani happened not sometimes not in 1981.
Rather, the respondent has
81.
been arguing to the contrary. They are saying that under Hindu law, partial partition is not permissible.
No, it is permissible under the Hindu law.
We'll see. We need to see. You need to
Yes.
answer that.
Yes, I will answer.
He has been saying that under the Hindu law, there is partial partition is not permissible. But so far as Mohammedan law is concerned, there is no legal power.
Then I'm out of court. Then this submission.
On
has no
this
submission.
submission, straight away come to that judgment. So far as partial partition amongst Hindus and amongst Muslims is
There are-
permissible or not
There are
permissible.
umpteen number of judgments.
One
which
is
say-
sufficient.
No, No, for Mohammedan law I will give not 2 judgments. For not Hindu law I can give not number of judgments which says partial partition can happen, but not for Mohammedan. Right from 1971 onwards, not can we take the first judgment.
Just one judgment is sufficient.
I will give no time. I'm giving the first judgment on the issue. 71. 71 is Muslim. 71. 1971, Volume 1, Supreme Court cases 597. This is not an authority.
1971, Volume 1,
Supreme
SCC
Court cases 597.
590.
This was not the first judgment. This has been subsequently confirmed by a catena of judgments. I will only be referring to 2 judgments. For 1971 and then now not 2024.
Which paragraph of this judgment?
Yes, please. Paragraph note 20. Not straight away come to paragraph 20. Other note of factual aspects will not be relevant, but it is actually relevant for the fact that not how the case was not initiated. But nevertheless, notes point of limitation and other things were raised. Paragraph 20. The cause of action for partition of property is said to be a perpetually recurring one. See, Mosram Chakravarti and other versus Ganesh Chandra Chakravarti. In Mohammedan law, the doctrine of partial partition is not applicable because the heirs are tenants in common, and the heirs of the deceased Muslim succeed to the definite fraction of every part of his estate. The share of heirs under the Mohammedan law are definite and known before the actual partition. Therefore, on partition of properties belonging to a deceased Muslim, there is division by metes and bounds in accordance with the specific share of each heir being already determined by the law. So, partial partition is not permissible under the Mohammedan law.
There is
This
two
has
kind
been-
of partial partition. One is partition qua one of the legal heirs. Suppose there is non-joinder of some parties, whether it is permissible. And secondly,
With respect to the party, not if all the properties are in the hodgepodge.
yes,
And all the property, what the Hindu law says, and when a plaintiff files a suit for partition, without specifically claiming a partial partition, then he has to bring all the property in the hodgepodge. He cannot choose that only this much I am putting in the hodgepodge and other properties are not. But when he is claiming a partial partition, it is permissible under the Hindu law. Only that much property can be partitioned, leaving aside the other properties in joint place. But here it is a tenant in common. In a Mohammedan law, the shares are pre-decided and it only effectuates after the death of the owner. Immediately upon the death, the entire property has to be partitioned because there is no concept of a partial partition. Because everybody has a definite share. Even if he is joined or not joined, he has a definite share.
if there are two properties, property A and property B, in property A, everybody has a definite share.
Even in B,
Even in B,
Yes.
suppose B is excluded
it
in a
cannot be.
partition
That is
suit.
what the judgment says. It cannot be because in Mohammedan law there is no concept of a partial partition. Partial partition cannot happen in a Mohammedan law.
May I just clarify?
So you need not. Let him
The
finish.
very concept is reverse. Doctrine of partial partition and partial partition are two different things.
We'll hear you. We'll hear you. Please hold on for some time.
Mullah is very clear.
Then the judgments I have not taken not the Hindu law, but I will be not once not I can give a number of judgments. They say that not partial partition can be applied for, and it can be requested by the not to the court, and the court can grant a partial partition, but not in case of a Mohammedan, because the partial partition doctrine, partial partition is not it is foreign to the Mohammedan law, because it is not a jointness of ownership; it is tenancy in common. It is a basic principle on which what it is considered. Then note 2024 SCC online, Supreme Court 3809.
Paragraph.
Paragraph notes. 20 of this note, the judgment of 1971 has been quoted. Paragraph 17 onwards, no? Kindly see paragraph 17. Let us now turn to the position as it is under the Mandal law.
Yes. Para 17.
Here, Lord, this is also an authority with regard to what has dealt with not certain Lord provisions of Hindu law vis-a-vis the Mandal law. Here also, Lord, the property was claimed to a gift. Is Supreme Court, online, SC 3809. First, kindly see paragraph 14 also not included with relevant notes. For a moment, we'll see paragraph 14. Tahir Mahmood, in his book, The Muslim Law of India, second edition, chapter 12, has provided for various concepts related to succession in Muslim law, which distinguish it from other personal laws.
You are reading para number?
14.
Yes.
The Muslim law of succession is basically different from the parallel indigenous systems of India. The doctrine of Janm right by birth, which constitutes the foundation of the Mitakshara law of succession, is wholly unknown to Muslim law. The law of inheritance in Islam is relatively close to the classical Dayavaga law, though it differs also from that on several fundamental points. The modern Hindu law of succession is more closer to the classical system, which is proximate to the Muslim law of inheritance. Division of heritage Daya into Sapratiban, that is obstructed, and Apratiban, unobstructed, self-acquired and ancestrally equally foreign to Muslim law. Whatever property one inherits is at Muslim law one's absolute property, whether that person is a man or a woman. In Muslim law, so long as a person is alive, he or she is the absolute owner of his or her property. Nobody else, including a son, has any right whatsoever in it. It is only when the owner dies and never before that the legal rights of the heirs accrue. There is therefore no question of a would-be heir dealing in any way with his future right to inherit. Indian legal concepts of joint or undivided family, co-partnership, karta, survivorship, and partition, etc., have no place in the law of Islam. A father and his son living together do not constitute a joint family. The father is the master of his property, and the son, even if a minor of it, if he has any, the same is the position of brothers or other living together. Unlike the classical Indian law, female sex is no bar to inherit property. No woman is excluded from inheritance only on the basis of sex. Women have, like men, right to inherit property independently, not merely to receive maintenance or hold property in lieu of maintenance. Moreover, every woman who inherits some property is like a man, its absolute owner. There is no concept of either a citizen or a woman's limited estate reverting to others upon his death. The same scheme of succession applies whether the disease was a male or a female. The position and devolution of property under Mandal law has been succinctly captured in chapter 22, Law of Succession in Mullah, and inheritance of Mullah on Mandal law. In the following terms, all property is devolved by succession. So the rights of heirs come into existence only on the death of the ancestor. The whole property vests in them. The Mandal law has well-defined rules of inheritance that comes into effect upon the death of the ancestor, and its policy has been to restrain the owner from interfering in such well-defined rules. Transfer of property, if required to be made during the lifetime of a person, they may do so primarily by way of gift. Other methods include the writing of a will, but even therein certain restrictions have been postulated. Prior to looking to the above said sources, a general understanding of partition would also be instructive. Advanced law lexicon defined partition as a separation between joint owners or tenants in common of their respective interests in land, setting apart such interests so that they may enjoy and possess the same in severalty. In Subkaran Bhuvna, it said thus: partition is a redistribution or adjustment of pre-existing rights among co-owners, co-partners. resulting in a division of lands or other property jointly held by them into different lots or portions and delivery thereof to the respective allottees. The effect of such division is that the joint ownership is terminated and the respective shares vest in them severally. A partition of a property can be only among those having a share or interest in it. A person who does not have a share in such property cannot obviously be a party to a partition. Separation of share is a species of partition. When all co-owners get separated, it is a partition. Separation of shares refers to a division where only one or only a few among several co-owners get separated, others continue to be joint or continue to hold the remaining property jointly without division by means and bounds. For example, where four brothers owning a property divide it among themselves by means and bounds, it is a partition. But if only one brother wants to get his share separated, another three brothers continue to remain joint, there is only a separation of the share of one brother.
So therefore,
This is permissible in Hindu law.
therefore, yes. Therefore, the partial partition has two aspects. One is only one of the brother is claiming his share. Only his portion will be separated, and rest would continue to remain joint.
Only in Hindu law.
This is permissible in only Hindu law.
Hindu law.
Right?
It is
But-
foreign to the Mohammedan.
And this is also a partial partition,
Yes.
right? This kind of partial partition is not permissible under Muslim.
No.
It does not say that partial partition qua one or the other property is not permissible.
But this is not one.
These are two different. Kindly first.
Not the partial partition is not qua the co-sharers,
Yes.
and partial partition can
Qua
also
the
happen
property.
qua the property.
Yes.
So both mode is permissible under the Hindu law, and it is foreign to the Mohammedan.
No. So first part, so far as qua co-partner or qua one of the brother or qua one of the co-sharer, is permissible under Hindu law, and it cannot happen under Muslim law, right? There is no dispute on that. But qua
Properties that would also
Is
have
is there any law which says that all the properties are to be necessarily
yes,
included?
yes. Because it
Kindly
is a-
show me one
yes, yes,
judgment
yes.
to that
Not
effect.
because the principle of Mohammedan law is very different because it is a tenants in common.
Yes.
Jointness of ownership and
See,
tenancy in
there are
common is
10
two different
buildings.
aspects.
There are 2 buildings, right? Upon a death of a person, now there are 5 co-sharers under Muslim law, right? They become co-sharers, right? Then if one building is separated, their separate right qua another building remains intact.
It's
So
not
I
in
just
any
want to
law.
know from you, is it necessary that the entire property is required to be put in for the purposes of
Because not there is no jointness of ownership. I am not trying to make the submission to not put forth this notes is that it is no jointness of ownership. Therefore, it is only partition can only be effected after the death of the owner. So when the death happens, the person has irrepartible share,
Yes.
and it's a pre-decided share. So he cannot remain. There was no jointness when the father was alive, and there is no jointness even now. So it cannot be said that the parties are in jointness for the other properties, and it is with respect to this property.
Show
it
me
is in
some
joint parties.
authority that all the properties are to
No,
be.
I am not only submitting this principle. That what
Yes.
is this? What Marod is asking. Let
You
us
see, there
understand the
are
jointness of
2
ownership.
things. One is that the principle stands decided by Honorable Supreme Court, matter over. But if the principle has not yet been decided by Honorable Supreme Court as to whether all the properties, irrespective of the jurisdiction, it may be a property in England, it can be a property anywhere, it can
And
be a
what will be the
property in
status of that
US.
property? What will be the status of the property? Jointness?
Yeah, no, so I just want to
There is no
know.
jointness.
I just want to know: is it necessary that all the properties?
Exactly. But therefore, the properties and partition, partial partition, partition is respect to the co-sharers, co-sharers, the property.
Yes,
Partition is not in vacuum.
that's right.
So co-sharers, there is no jointness even after the death of the father. Suppose father is not dead, his sons are not in
They
jointness.
are just tenant in common.
They are tenants in common.
Therefore, if they are
With their
tenant in,
defined share,
if there are tenants,
already predetermined.
fair enough. If they are tenants in common, then that particular severance of status of tenant in common can take place qua one property,
No.
and it will also take place qua another property.
I get to differ.
That is the law.
I would be not differing my pilot's not views on this, not on the issue that not once jointness is not there. So it can only not happen in case of a jointness of the ownership. That some property can be bifurcated, some can remain in jointness. But when the jointness is not there, the shares have to be divided. The impartible shares has to be given to each of the lots co-share under the Mohammedan law, because this entire concept of jointness of ownership is not there in the Mohammedan law. It is tenancy in common. So I cannot say that I am tenant in common. With respect to this property, I will be getting 1/3, and the others I will jointly enjoy. You cannot. The properties has to be not
You
designated,
will
demarcated.
continue to remain tenant in common to another property.
No, tenants in common, not tenants in common is a principle where what the father is alive, but once he is not there, it has to be partitioned. It has to take effect. The shares and lot of the lots heirs will have to be decided and divided amongst not this tenancy in common with a predetermined share already decided under Sharia law.
The example,
adjudication is required.
the paragraph 5 which you have read and the example which has been given therein, it relates to, so far as the example is concerned, it relates to partial partition qua one of the co-partner. And that principle is, he will also not dispute, is not applicable under Hindu. But the point here is whether there can be a partial partition qua one of the properties.
What I have understood, but not there cannot be a partition among the co-sharer living aside the property. Partition is always not with respect to the properties in question. It is not in isolation. I cannot see not the share of a co-sharer not in exclusion of the properties. The co-sharer and properties have to go together, and then when there is no jointness, there is a partition. One partition effected, remaining parties cannot remain in jointness. The other party already stands there. All the parties have to be partitioned accordingly. Partial partition cannot happen either who are the co-sharers or not with respect to the property. Paragraph 17 note and later note the facts in the 1971 judgment will make it more clear. The facts note there also because oral gift notes was the issue. Here also in 2024 the oral gift was the issue. Let us now turn to the position as it is under the Mohammedan law. The right of an heir apparent comes into existence for the first time on the death of the ancestor, and he is not entitled until then to any interest in the property to which he would succeed as an heir if he survived the ancestor. See so and so. Wherein a bench of 300 judges observed, albeit in connection with renunciation of inheritance as under Anglo-Mohammedan law. For the sake of those readers who are familiar with the joint ownership of father and son, according to the most widely prevalent school of Hindu law, it is perhaps desirable to state explicitly that in Mohammedan law, as in Roman and English law, nemo est res viventis, a living person has no heir, and an heir apparent or presumptive has no such reversionary interest as would enable him to object to any sale or gift made by the owner in possession. The converse is also true. A renunciation by an expectant heir in the lifetime of his ancestor is not valid or enforceable against him after the vesting of the inheritance. It is also important to note that the doctrine of partial partition does not apply to Mohammedan law, as heirs therein are tenants in common. Succession is to definite fraction of the estate in question, as his lordship then was wrote in Sayyid Sahib 71 Supreme Court. In Mohammedan law, the doctrine of partial partition is not applicable because the heirs are tenants in common, and the heirs of the deceased Muslim succeed to the definite fraction of every part of his estate, not to the partial estate, every part of the estate. The shares of heirs under Mohammedan law are definite and known before actual partition. Therefore, on partition of properties belonging to a deceased Muslim, there is a division by metes and bounds in accordance with the specific share of each heir being already determined by the law. Every state, every part of the state note is to be affected not within the party. Then it goes on to say what are the sources of Mohammedan law. It has referred to Faizi also at some place. Paragraph 24 note Faizi has been mentioned. Paragraph 24. The three principles of oral deed note gift has been mentioned: manifestation of the wish to give on the part of the donor, acceptance of the donee, and taking the possession of this matter. Then note oral deed note whether it was contemporaneous or even here was a case that oral deed of gift was made, and also in the Rasida Khatun case, celebrated case of 19 notes 2014, that notes oral gift was made, and subsequent thereto after 7 or 8 years, a written instrument was created acknowledging the oral gift made. So the note one string of judgment said that there was an oral gift in writing Therefore, it was contemporaneous document required a registration. Supreme Court held not in Rasida Khatun, and even in this case, doesn't require because it is only acknowledging a gift already made earlier, and with the three principles which is manifest as per the 5G, that notes intention, acceptance, and the possession. These are the three only principles which will prove that there was an oral gift.
This is on the point of partial partition.
The question of gift, oral gift,
Oral
whether
gift.
it requires a registration,
No,
and whether
it is nobody's case that it requires
no,
registration.
this judgment, this
Yes,
judgment,
this
this judgment
judgment.
is not the issue. Whether there was an oral gift, whether it requires a registration, whether the principles of oral gift not have been fulfilled not in this case. This was the issue, and that not partial partition was not an incidental issue which was raised, which has been answered that the entire estate, every part of the estate is to be decided because there is no jointness of ownership. Here the distinction of Hindu and Muslim law was noticed here that when there is jointness, I can leave aside some properties, but not in case of when the right itself accrues after death of the ancestor. During his lifetime, no son can claim any interest in the property because it is not his. This
He
is
has
the
got no right.
no right. So when the right accrues, then he has right on the every estate of the. It cannot be not partial, not eviction, partial partition with respect to co-op, one sharer or co-sharer or the property.
So co-sharer, there cannot be partial partition. I have no doubts on that. But property,
It says not entire all part of the estate. 71 Supreme Court says all part of the estate.
all part of the state means that if there are 10 states, all part of the state, they will have equal shares. Or whatever be the proportion. That does not mean that
The state plot is a property, all part of the property, all property. I cannot make a distinction. Property is divisible into different categories, and only that property. And there can be property A, property B, and property C. Estate is the total A, B, and C. Total estate and total property is the estate of the Lord's ancestor. And what the plaintiff notes, if one were to take the evidence of the plaintiff, PW1.
you are reading from the judgment itself.
Judgment I will come not because judgment
No,
only
whatever,
refers to.
if you want to read.
No, I am not interchangeably. I am referring to both because not have not the cross examination exact statements there.
So,
it would be more
I just-
pertinent to
I just want to,
look into the.
if it is possible, please let us know that for PW1, which all paragraph in particular you are like. First you give me the paragraph number, then we will read the whole text. There is no problem if you want. There is no problem.
In the judgment or in the evidence.
Wherever, whatever we actually in first appeal we should read it from the evidence itself instead of reading it from the judge.
Evidence note the cross examination.
Cross examination para number. In particular, you can refer, it's okay, or you just want to read it and emphasize while reading, that is also.
Paragraph number note is paragraph 34, 35, 36, 37, 38, 39, 40.
34 to 40.
In then again notes
पढ़ लेते हैं ना PW, इतना क्या इतना देर में पढ़ ही नहीं क्या.
paragraph 56, 57, 58.
PW1 56 only.
Everywhere is saying that there are properties. Everywhere. उनका cross examination उल्टे पे लिखा हुआ है.
let us take it that there are properties involved.
He admits that there was no partition of those village property.
Let's take it that there was properties involved.
First note he says that there are 13 bighas of land which was left at the time of the death of Abdul Ghani.
We take it. We take it that there are properties involved.
And then
It is for them to respond.
Paragraph 61 he says that I do not know the share of the sister because there was no partition. He says that. How much share each got because there is no partition I do not know. कितना जमीन पे मेरे पिताजी खेती करते थे, कितना जमीन पे वो लोग करते थे, ये मुझे पता नहीं है. गांव की संपत्ति का ब्यौरा इस केस में नहीं किया गया. पैराग्राफ 58. उनका पूरा कितना जमीन बेचा है मुझे नहीं मालूम. अब्दुल गानी का संपत्ति का बंटवारा नहीं हुआ है. पैराग्राफ 58. अगेन नोट इन पैराग्राफ 61 ही सेज रिटन स्टेटमेंट में लिखी गई बातों की जानकारी मुझे है. अब्दुल गानी का 4 बेटा 5 बेटी थी. बेटी का हिस्सा मिला मुझे जानकारी नहीं है चूंकि बंटवारा नहीं हुआ. Repeatedly saying that बंटवारा नहीं हुआ. पैराग्राफ 58 इन पैरा 61.
कितनी जमीन बिक गई है इसकी भी जानकारी नहीं है.
हम
कौन कौन
लगाए
बेचा
थे.
ये भी नहीं मालूम.
हम लोग एलिगेशन लगाए थे कि ये लोग जमीन बेच रहे हैं. तो ये बोला था कि हम लोग नहीं बेचे. पैराग्राफ नोट 62. इसकी जानकारी मुझे नहीं है. ऐसी बात नहीं है कि अब्दुल गानी के मृत्यु के उपरांत उसके पुत्र ने जमीन बेच दिया. बेटी लोग लेती है बेची है कि इसकी जानकारी मुझे नहीं है. Who is denying that I do not know, but he is saying that there was no partition and there are properties in the village. Exclusively saying that there was a house also where the parties used to live together and there was no partition. So I now proceed. Then similarly PW2 also is saying the same thing. Sakiram. The judgment note to kindly see internal page 25.
Yes.
So this starts from the previous page, last line. At present, some land are left. Abdul Ghani was farmer. He had about 30-42 bighas land. At present, some land are left. Only one person's house is there. Rest were sold, but land and house of Bhojpur was not partitioned. Further, it recalls that recently about 4 to 5 bighas of land remains in the Bhojpur. But this entire statement thought in this particular paragraph is there. Then next page, note kindly see page 26. Now it is PW2's statement I am reading here. Internal page 26. First paragraph, 7-8 lines from the top. Further, he deposed that after the death of Abdul Ghani, his entire property was not divided, neither partitioned. Further, he deposed that Abdul Ghani had not made any gift or will. In 1987, the defendants were asked to partition the properties, and in which Bhojpur's land were also included. During the lifetime of Abdul Ghani, there were only discussions regarding the partition. Under the Mohammedan law, during the lifetime, nobody can seek a partition from the father. Further, he deposed that in 2013-14, they were further asked regarding the partition of entire property. This case was filed for only one land. Then what is statement of note? The defendant's notes. Have you noted? No, PW3 also, no, there are only 3 witnesses. PW3 also has said the same thing. Paragraph 30 of the not cross examination of not DPW3. भोजपुर के जमीन में हिस्सा नहीं मिला, अभी वहाँ मकान नहीं रहा, जमीन थोड़ा बचा होगा। भोजपुर का मकान जमीन का निश्चित रूप से मुझे मालूम नहीं। मेरे नाना का घर भोजपुर, पैराग्राफ नोट 29, जिला नालंदा का मकान बड़ा मकान था। वे खेती बाड़ी करते थे। कितना बीघा जमीन कृषि योग्य था पता नहीं। भोजपुर का जमीन में हम लोगों का हक है, सभी का हक है। Now let us come to notes defendant number 1. Our case with regard to the notes oral gift and how it has been dealt with. May I not start with note statement?
Just a minute. Keep writing back. So your point is that there is enough material to show that properties were in Bhutpur and it was a case of partial partition without disclosing that there are properties at.
Therefore, the first thing, even in not in the plan, there is no mention that there are other properties. There is no mention that this is the hotspots of the total property, total estate of the ancestor, for which the partition is being sought. It is also not a claim of the plaintiff, and it came out not openly in the evidence, oral evidence in cross-examination. Everything was said not openly.
In plain as well as in written statement, there was no mention about Bhutpur property.
But written statement what was filed by not getting not the stand of oral gifts, when not other properties stand not amendment was filed which was not allowed, to which not CMP was preferred, but before that no, the judgment came. And therefore that CMP note is to be withdrawn. It was not no notices were issued by your lordship notes in that CMP. Calling for the records of the case on 31/8/2024, 31st August. But by that time, the judgment notes itself came. And let's see note 3 notes paragraphs from the DW1 statement. Paragraph 13.
DW1?
Yes.
Paragraph 13. What do you want to say? of cross-examination or
No,
cheating?
notes no the evidence. Evidence on both notes, paragraph 13.
That's right, it's there. Tell us, what do you want to say?
My grandfather, Sheikh Abdul Ghani, while he was in possession of the aforesaid land, recorded in plot number so and so area measuring 1.5 bigha, Moza Mango, he orally gifted the same in the year 1967 in favor of my father, in presence of Abdul Ghani, Tahir Hussain, Gujar Ali, and other respectable persons of our community. The declaration and acceptance of gift was accompanied by delivery of possession of the aforesaid land by my grandfather, Abdul Ghani, to my father, Wali Alam. Since the aforesaid oral gift made by my grandfather Abdul Ghani, my father came in exclusive peaceful possession of the aforesaid plot, area measuring so and so as absolute owner thereof, and also constructed boundary wall and house in a portion of the aforesaid land. My father, while in possession of the aforesaid land, the present survey settlement operation commenced in the year 1972, and the present survey settlement operation, which was finally published in the year 1979, the aforesaid land and structure standing thereupon, recorded in the name of my father. My father was in peaceful possession of the said property as absolute owner thereupon, and got his name located in the office of superior landlord with respect to the aforesaid property, and has been paying rent, municipal charges and other charges in the name of the
So, declaration and acceptance of gift was accompanied by the delivery of possession.
and they live there and
Para
subsequently,
14.
and that mutation and not
Is she a witness?
Oh, what's
Is she a witness to the declaration, the acceptance and delivery of
oh,
possession?
what's
DW1?
oh, he is the grandson of Lord Sheikh Abdul Ghani. His father was not a witness, but not his father died.
His father was a witness.
He was not-
Late Wali Alam. He is the
Wali
son
Alam
of
was
the defendant number 1.
Wali Alam is the Doni,
Yes. He is the
and he is the son of Wali Alam.
So he is the son of the defendant number 1.
One. No, okay. Yes. Original defendant,
Yes.
son of
But he is not a witness to the gift.
in the case of oral gift. Not suppose not a case is filed of oral gift in 1967. Mutation entries made in 72, 73, and then 79 and then 87. In 2014. After second generation or third generation, what kind of
No,
person
he is
remember?
63 years of age. He must have been born by then.
No, thing is that I'm only referring to the principle. That if a suit is filed not after let us say 50 years, when one generation or two generations have already notes expired and they have gone. Can a
Only
person not remember-
circumstances will.
Only circumstances. And can a person say that on which date the deed was given? That not the trial court has said the date is not given. How can not the third generation or the
See,
fourth
your
generation remember the
evidence
date?
was there were 3 witnesses to the gift also.
All these three witnesses was had probably not had. They were not witness in this suit.
No, they are not witness, but it is your evidence that
Yes.
there were 3 witnesses to
There were three
the.
witnesses to the
Why
order.
didn't you produce even one of them?
Probably not. They were not there. I think.
There were no. Probably means there is no
So
explanation.
there is no explanation, but probably not. They were not alive.
We do not.
I will not. I do not. I will not say. We cannot say.
There is no additional
cannot be a
evidence saying
presumption.
that they were not alive.
There cannot be a presumption.
Because you see, it is one
the
thing to
suit
say.
can be filed in
You see,
2014. Evidence have been recorded.
In case of oral gift, it may not be necessary to have a witness also.
circumstances.
It may not be necessary to have a witness.
Only
But
circumstances.
once you come up with an evidence that there were, and in the written statement which was filed by defendant number 1, he categorically stated that oral gift was done in presence of witnesses, and he did not name any of the witnesses. During evidence it has come, the name of 3 witnesses have come. That has come during evidence. But none of them has deposed before the court.
Defendant witness, other defendants have
When-
got said
when
that
a
there were other
party-
persons also present
when-
during the time
When
of
a
the
party to the transaction, when a party to the suit is not producing the best witness. Your best witness was all three persons who were present, who could have
But the
come
other
and said.
defendants, other defendants not the
None of the defendants were present at
other
the time
defendants.
of.
Number 2 and 3 are not the family members. 2 and 4.
Son, 3 is the son.
Nashad Ali,
Yes.
Pita Gulzar Ali. 4.
1 and 3 are sons.
Defendant number 4, defendant number 4 is not the member of the family, but he
This
says
number
that there
4,
were
defendant number 4.
other persons in whose presence, in his father's presence, the deed of oral gift was made, and he is aware that he is
Sorry.
the defendants are residing
Yes,
in the.
you are saying.
Yes, yes, yes. But he is saying that we are aware as a in the community that they are living in the house as under the gift, oral gift. And he said that he was present at it. He was not mentioned in the evidence. He said that I am present, but it is only an attempt.
Present where?
Time of gift. And there
Which
he
is that
said,
statement? That he is also a witness to the gift.
no, we have not said that he was a witness because I have given only 3 names. He said that in presence of the respected members of the community, a gift was given, and I know that they are living in the possession of the house under the gift. That is the circumstantial evidence.
No, he says that I was also there.
Yes, of course.
DW4 says I was also there.
As a child, he was also there in presence of other persons.
7 to 8 years of age.
In
16
presence,
years.
in presence of other persons, respected members of the community, the oral gift was made. That is what he is saying.
But none of the so-called respected members of the society or the family have come up before the court
He
to
is one of
say that yes, in my presence it happened.
He is one of them, no? DW4. He was present as a child. And his father was also there, but his father certainly not is dead. So he was not alive when the evidence was being there. Now let us see how the court has not traveled to decide.
Let us see the discussion of evidence of DW4 by the court.
Findings. Now the findings are very not abrupt, not to say the least. Let us understand what is it. But he records all these statements, evidences of W1, 2, 3, W1, 2, 3, 4. Kindly see note findings. It starts from page 42.
From where do you say that father of DW4 was not alive at the time of his illness?
It's not there.
It's not there.
मैं अपने पिता के साथ उस समय उपस्थित नहीं लिखा
नहीं, और ये नौशाद अली उम्र 72, पिता गुलजार अली. From where do you say that Gulzar Ali was dead?
72 साल का
ऐसा assumption से नहीं चलेगा.
कम से कम 20
125 साल कोई ऐसी बड़ी बात नहीं है.
तो 92 साल का तो उम्र हमको नहीं लगता है कि वो होना चाहिए उस समय.
ये कम से कम लेट में नहीं लिखा हुआ है, उसके एविडेंस में लेट नहीं लिखा हुआ. और कुछ ऐसा आ नहीं रहा है जिससे ये पता चले he was not alive at the time when he had deposed. He says मेरे पिता के सामने जिस समय मौखिक दान अब्दुल गनी द्वारा दिया गया उस समय मेरे पिता गुलजार अली, अब्दुल मतीन, ताहिर हुसैन तथा हमारे समाज के गण्यमान्य व्यक्ति उपस्थित थे तथा मैं अपने पिता के साथ उस समय उपस्थित था. He is specifically taking name of 3 persons.
But he had expired. He
ऐसा
mentioned as
एविडेंस के बाहर चीजें नहीं देखेंगे. ओरल इंस्ट्रक्शन पे चीजें मत बताइए, दिख रहा है रिकॉर्ड पे तो दिख रहा है।
तो जो है वही इम्पोर्टेंट है, तुम नहीं पढ़ सकते हैं। It is admitted fact that not, but I am taking instruction that not he was not present. Of course, he was not here time. Late लिखा होना चाहिए था, लेकिन लेट नहीं लिखा हुआ, इसमें रिकॉर्ड नहीं किया हुआ एविडेंस में, wrongly recorded as
और बाकी दोनों के
बाकी तीनों में लिखा हुआ।
ये तो आपका एविडेंस ऑन एफिडेविट आपने बना के फाइल किया है, उसमें भी लेट नहीं लिखा।
क्रॉस एग्जामिनेशन में नहीं है।
नहीं नहीं, ये तो चीफ में है ये बात। पैरा नंबर 4, the मैं नौशाद अली, उम्र 72 years, पिता गुलजार अली, यहाँ पे भी लेट नहीं लिखा। और साथ में 3 आदमी का नाम बोल रहा है, गुलजार अली, अब्दुल मतीन एंड ताहिर हुसैन। None of them are before the court.
The witnesses which have been named, who were present, in whose presence the oral gift was made, are not the witnesses before the court. Considering the fact that it is witnesses, not the evidence are being recorded in 2023-24 and the year of 1967, these circumstances not should be looked into, coupled with the fact that the plaintiff himself is not saying anywhere that he was in joint position living with the in constructive position of the building, he lived there in the same area, he lived separately. Everybody knew, only because the property became valuable and development agreement happened that the suit was filed.
Anything
कोई
else?
तीनों विटनेस मारेगा तो आपको एविडेंस तो बोलना है, वो विटनेसेस नहीं आपने कहीं कहा है। How can you be presumed to have murdered him? Even if he is 150 years, I will assume that he is alive. You cannot presume something. Now, Lord, the way it has been considered, and Lord, he has started findings, Lord, he started giving Lord from page 33, 32,
Yes.
internal page 32. He only records not what Peter 1, 2, 3 says, he records. And then there are other properties and everything, and Lord, everything is he records in the findings also. But he has not given any finding on that. Page notes 37, internal page 37 of the judgment. On behalf of the contesting defendants, 4 witnesses have been examined, and out of the 4 witnesses, there were 1, 3 are the sons of the deceased principal defendant number 1, Wali Alam, DW1, Sanahullah, in para 43 of his constitution stated that disputed land was gifted by Abdul Ghani in the time he was about 7-8 years old. The gift was given orally in the first time in the examination in CBT known as Gulzar Ali, Abdul Mateen and Tahir Hassan were the witnesses before whom the alleged oral gift was made and accepted. DW1 did not disclose the date, month and place of the oral gift. DW2, Sohail Ahmad Sufi, captain of this cross-commission, and said that he has been living in Dhanbad since 1958 and started coming to Jamshedpur since 75. Further, in parallel of this cross-commission, he has stated that Waliullah is his relative. Recently, he has become a Samdi of Waliullah. His daughter is married to Waliullah's son. Further, in paragraph 9, in 19 of his cross-examination, he reports that oral gift was made in 67. At that time, he was just 14 to 15 years. This witness also did not disclose the date, month, and place of oral gift. In the first time in his examination, in chief would repose that Gulzar Ali, Abdul Mateen, and Tahir Hassan were the witnesses for whom the alleged oral gift was made and accepted. This witness seems to be an interested witness. Even before Nashad Ali, in para 17 of his grounds, considered in the year 67, his age was 16 years. He is permanent president of Jabalpur, Madhya Pradesh, but his birthplace is Sakchi. Further, in para 27 of his cross-examination, he reported that it is true that Abdul Ghani gave the house to his son Wali Alam to reside and use for his business. Para 3 and 4 of his examination, he reports that in 67, Disputed land was given by Sheikh Abdul Ghani to Wali Alam through oral gift, and that time Gulzar Ali, Abdul, Mateen and Qayyum were present. He was also present with his father. None of the alleged three witnesses were produced before the court as witnesses, and it is also not aware that they are not alive or not traceable. None of the three defendants' witnesses, DW1 to 3, took the name of Naushad Ali. From perusal of case record, it appears that while instant suit was filed and principal defendant number 1, Wali Alam was alive, who appeared in the suit and filed his written statement on 12/3/2015, and in his written statement he claimed that Abdul Ghani during his lifetime, the year 67, already gifted the suit land to him in presence of witnesses, which is within the knowledge of the plaintiffs and other legal heirs and successors of said Abdul Ghani. And since then he is in peaceful physical possession of the suit land, but in his written statement, date, month and place of oral gift are not mentioned. It is not mentioned as to who were the witnesses before whom the alleged gift was made and accepted. None of the legal heirs of late Abdul Ghani were the witness in the alleged oral gift. According to the Muhammad law, there can be a valid gift if there are three essentials of the gifts are satisfied: declaration, acceptance, delivery of coercion. On the point of oral gift, Learned Counsel for the contesting defendants had relied upon the decision in the year 2010, so and so. A gift indisputably becomes complete when a person transfers with immediate effect the ownership of his movable or immovable property to another person. That other person himself or someone else with his consent takes possession of property gifted. Under Muhammad law, it is a contract which gives effect through offer and acceptance. The condition to make a valid complete gift under Muhammad law are as under. So next page notes. It is well settled that the reason of the valid gift, the thing gifted has gone out of the donor's ownership, the same cannot be revoked. The donor may lawfully make a gift of property in the possession of a lessee or mortgagee for effecting a valid with the delivery or constructive possession of the property to the donee which serve the purpose. Even a gift of a property in possession of trespasser is permissible in law, provided the donor either obtains and gives possession of the property to the donee or does all that he can do to fulfill, to put it within the power of the donor to obtain possession. So far, the oral gift of suit land concerned, there is no cogent evidence adduced on behalf of the contesting defendant to prove the same. Perusal of Appendix C filed by the contesting defendant, which is the correction slip dated 87. This shows the mutation is on the basis of Kapiyan Kohacha, which falsified the story of contesting defendant of oral gift. On the point of oral gift, Learned Counsel for Plaintiff had relied upon the decision recorded in AIR 1966, Supreme Court 1194. Oral gift. Question regarding valid oral gift underlying the Muhammad law was the subject matter of consideration in this case. Dealing with the facts of the case, the Honorable Supreme Court observed. The appellant examined himself as witness in this case. He said that the gift was made on 10/2/43 in the presence of his parents. His mother was alive, but she was not examined as a witness. Date of the gift was not mentioned in the plaint or in any other document. It was disclosed for the first time in the witness box, and even then it was not made clear how he remembered the date in the absence of any record. Considering all the circumstances, the High Court held, in our opinion, rightly that the appellants failed to prove the alleged oral gift. Another case on the point of oral gift has been cited by the plaintiffs, 2009 SSC 1 in Andhra Pradesh. So and so decided as so and so. Here also there was conflicting statement that date was different. DW2 stated that oral gift was made on 18/3/1969, whereas according to the contents of written statement, it was made on 1/3/1969. There is serious discrepancy as to the persons in whose favor the oral gift is said to have been made. Therefore, it was disbelieved. Oral gift is typical facility which is available exclusively to Muslims. In the ordinary course, a gift is required to be made through a registered document approved in the form of no. This is not setting, it's not in dispute. From the above, perusal of the above decision is found that these both decisions are reliable from the instant suit. It is not disputed between the parties that the common ancestor of the parties was residing at Bhojpur and Sheikh Khani left some landed property and housed in today's Bhojpur and has not been included in this suit for partition, and it is admitted fact between the parties. PW1, Mohammed Mahmood Alam and Paragraph 35 of his cross-examination has admitted that at the time of death, Abdul Ghani about 12-13 bighas land was there, where his land, agricultural lands and house were there. Further, this witness admitted that Muhammad Alam so and so clause has stated that his grandfather Abdul Ghani was residing at Yofur, was farmer and he was about 32 bighas land. Further in para 25, the clause submission witnesses admitted that father and uncle had also sold some land in Bhojpur. PW5 in 29 of the clause submission admitted that his paternal grandfather was permanent resident at Bhojpur. They used to do farming and cannot say how much land was used for cultivation. They have not got any share in Bhojpur land. PW1 in para 19 of the clause submission stated that both the parties are legal heirs of Abdul Ghani and the disputed land has not yet been divided amongst them. PW2 in para 18 of the clause submission stated that after the death of Abdul Ghani, disputed land has not been divided. PW3 to 4, para 41 of the clause submission stated Abdul Ghani's property has not been divided yet. From perusal of Exhibit A, it's a hard copy of sale deed, so and so, all sons of so and so. From perusal of evidence orally as well as documentary produced by both the parties, it appears that there are unity and joint possession of the parties over the Schedule B property. And all the parties to the suit are having their respective undivided share and portion of the Schedule B suit property as per Muslim law and Sharia, and which has still not been partitioned in between the parties to the suit by means and bounds. As discussed above, it is special here. Disease principle, so and so was in occupation of the Schedule B property who has been allowed by the other parties to the suit to take in use in occupation of the Schedule B suit property. Moreover, DW4 in para 1 source admitted Abdul Ghani has given house to his son Malik from staying in for business. From the above discussion and commission, previously there was no previous partition was made among the parties. But he specifically notes that there are other properties, and that only this particular party has been partitioned. He has not given any finding at all with respect to what has happened, whether it is a partial partition for this property only, other parties are in jointness or in tenants in common, that principle. And then he says here, there is unity of title in person between the plaintiff and defendant with regard to the suit property. There cannot be a unity of title.
That's right. That we have already noted.
That is all yours. But non-jointed I would not be yours. Non-jointed party. That is
We'll
law,
omit that.
not
Should I
the
record?
law, because they were disputing that she has not died pre-disease. If it was a pre-disease note, then she has no say.
So I
Even a
should
pre-disease
record,
son has no say. Yours.
I should record that.
I have not pressed the
Okay, sir. The learned senior counsel for the appellant has submitted that essentially 2 points would arise for consideration, and he does not want to press so far as the point of non-joinder of necessary party is concerned. The learned counsel has submitted that a finding has been recorded by the learned trial court with respect to non-joinder of necessary party, and the appellant is not aggrieved by such finding. With respect to the remaining 2 points, the learned counsel has submitted that there is ample evidence on record that there was property in the name of Abdul Ghani at Bhojpur, but the plaintiff did not disclose the properties at Bhojpur and sought partition of the property only at Jamshedpur. During the course of arguments, it transpired that even in the written statement, no such point was taken. However, he has submitted that there is enough evidence from the side of the plaintiff also that there were landed properties which were yet to be partitioned. The learned counsel submits that partial partition is not permissible under Mohammedan law, and for that purpose he has relied upon the judgment passed by the Honorable Supreme Court reported in 1971 within bracket 1 bracket close Supreme Court cases 597 and 2020. This is para number 20 and 2024 SCC online 3809 para number 17 in particular. 14 to 17. The learned counsel submits that the suit itself was not maintainable as
Because what is impermissible law cannot be granted not because the plaintiff has to stand on his own legs.
that's it. The learned counsel submits that the suit itself was not maintainable on account of the fact that it was essentially for partial partition, and once it has come on record that there were other parties, when there were other properties of the family, then under such circumstances, the suit was fit to be dismissed as not maintainable. The plaintiff has to stand on his own legs, and no relief can be granted beyond what is permissible under law. Yeah.
So this was judgment on the it was in regard to Hindu law. With regard to partial partition, defendant had not taken the plea in the settlement, and in the demand notice, legal notice also they did not mention that there are other properties. But the plaintiffs admitted in their document that there were other properties. Then the matter was demanded that partial partition. Then there is a hodgepodge of the whole property.
Partial partition for Hindu law is also not permissible.
Not permissible when you have all the property. You have to claim partial partition.
Okay.
If you are only claiming partition, then all the properties have to be included. But if you are claiming partial partition, it can be done for Hindu.
But it has to be properly disclosed in the
Proper
plaintiff.
property disclosure. इसका हम उसको ये दे देंगे
This is 2009
फुल
SCC
जजमेंट दे देंगे
52. The learned counsel has also referred to the judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket close 9 SCC 52. He submits that though the said judgment is in connection with Hindu law, but in the said case, the partition was sought for without taking a stand that the suit was for partial partition.
without suit was not for partition but all the properties are not done.
But
that partition
the
was-
suit was for partition, but all the properties were not
Not into the
forming
hospital.
subject matter of partition in the suit.
Therefore the matter was remanded to
And therefore
amend
the matter
plaint-
was remanded
to amend the plaint and to lead evidence.
to amend the plaint and to lead evidence. That's all.
Well, first address on,
Plaintiff has to stand on his own leg, 2015 volume 14.
so that is a settled law.
Anyways, he wants to
In fact,
cite it.
everybody has to stand on its own.
Such a principle based upon
The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2015, bracket close 14 SCC 450 to submit that the plaintiff has to stand on his own leg, and weakness of case of the defendant will not be a reason to decree the suit.
we are taking
बताइए respondent.
Please, Lordship may have the list of judgment and extracts of books which I have given.
Yes,
First, because there are only 2 points which I need to address on.
that's right.
The first is partial partition, and the second aspect is HIPAA.
That's right.
And the third, because they have given up, so I am not going to trouble Lordship on that.
That's right.
Safia Khatun is no more an issue, though I have basically spent an hour on that yesterday night, because there was in the yesterday.
Anyways, let's keep
Anyway.
it there.
Lordship, we have page 5 of
Page
this,
five.
running page 5.
This is the part of the judgment.
Yes, this is, I have annexed, and I have, Lordship, I have even given the book also.
Yes.
Lordship has the topic partial partition, the last topic of this page 5. This is out from the Mullah. Lordship has that?
Yes.
I'll just read this. Doctrine of partial partition is applicable only to a Hindu co-parsonry, where the co-parsoners are joint in state, and not to Muslims who are only tenants in common. Under the Mohammedan law, the heirs of deceased Muslims succeed to a definite fraction of every part of his estate. This is what my learned friend was also reading. Muslim shares are not obliged to sue the partition of all properties in which they are interested. There is nothing to preclude one of them from seeking a partition of some of items of the properties. This is the settled law by Mullah, and I'll have the judgments also. So, doctrine of partial partition is basically, Lordship, my learned friend was arguing hodgepodge. The concept of hodgepodge is in Hindu law. So, whatever the properties which all the legal heirs are the co-partner, co-owners, joint owners are put in the hodgepodge, and every property is basically partitioned among the legal heirs who are there on the date of partition. That is the difference between the Hindu law and the Muslim law. In Muslim law, the day a man dies, the legal heirs' shares are ascertained. So, in fact, in Muhammadan law, it is not the actual partition. It is not the determination of the shares. The shares are already stands determined. That is the difference between Hindu law and Muslim law. So, in fact, though we call it as a partition, in Muslim law, it is basically demarcating the shares and giving it to the person who is asking for it. Because he cannot basically vary the share he has. He has the share on the day the person from whom he is claiming the share has died. So therefore it is strictly not a partition even. It is demarcation of his share. That is a point. And if Lordship could see this, that is a very relevant point. The difference between the Muslims and Hindus. Hindus are co-partners, co-sharers, joint owners, which is alien a concept to the Muhammadan law. The legal heirs of the Muhammadans are tenants in common. Tenants in common, Lordship, if I just elaborate on the term, tenants in common means that you are recognized as one of the persons in that property. He was right in saying that there was no unity of title. There cannot be unity of title under the Muhammadan law. Your title, your share, your fraction of share is already determined. In a property, you are like a tenants in common, like in a property, if there are 4 tenants, one tenant wants to take his share, wants to forego his shares, want to sell his share. That is another difference between the Hindu and Muslim law, that as the share of a Muslim legal heir is determined on the date of the death of the person, he can even alienate his share. But under the Partition Act, it is not allowed for the Hindus. The undivided share he cannot sell unless it is partition. But in Muslim law, as the shares are basically ascertained, he can even sell to it. If Lordship put in the same compilation, the judgments, which 3 judgments I have relied upon, in serial number 12, 13 and 14, in the list of Lordship, the index, if Lordship could see, may mark that. The serial number 12, 13 and 14 are the judgments on partial partition. May mark them. And I will, Lordship, the relevant pages I have already mentioned in the index. The relevant pages and paragraphs are duly mentioned in the index itself, if Lordship has that. If I first take to Lordship, starting from page 146, the first judgment of this compilation, because my learned friend has only shown from the judgment of the Supreme Court saying that partial partition is allowed, partial partition is not allowed, and very particularly the court has asked a question as to, can you show a judgment which says that the Muslim has to include all his properties for asking partition? There is no judgment to that effect has been given by the other side, which shows that all the properties, if it is more than one, all has to be brought first and then it has to be partitioned, and one cannot be taken out from that for the purpose of partition. There is no judgment to that effect. Lordship may have page 146, judgment starts. The relevant Lordship is page 147 and 148. I'll start from para 8 of this judgment. This is Lordship of the Jammu and Kashmir High Court. This is 1959. I think I've given the
yes, it's
para 8. The doctrine of survivorship is not known to Mohammedan law. The shares of heirs under the Mohammedan law are definite and known before actual partition, where under the Mitakshara law, no individual member of an undivided family can predicate of the joint family property that he has a certain definite share. The theory of Hindu law is that every co-partner is entitled to the entire joint family property, that is to say, every part of it, and the share of no co-partner in the undivided co-partnery can be limited to a specified item of or property or to a definite share of it. This is certainly not the case regarding the heirs under the Mohammedan law, who are only tenants in common and whose shares are definite and specified in law. I'll further read, Lordship, from para 11, if Lordship. I'm only pointing out the relevant so that I don't waste time of the court. It does not appear to be necessary to dwell upon the aspect of the case at any greater length. It is not a correct proposition of law to say that Muslim shares who are tenants in common are obliged to sue for partition of all the properties in which they are interested. There is nothing to preclude one of them from seeking a partition of some of the items of the properties. It's a very specific what Lordship wanted to know about it. And further read, such a suit cannot be held to be incompetent on the title doctrine of partial partition, which is known and applied to suits for partition of Hindu joint family property. So and so judgment relied upon by the learned district judge are not relevant to the real point at issue. These decisions merely deal with the rule of Hindu law as applied to the particular facts. They have no application to a suit for partition by Muslim co-sharer, nor are they opposite to the facts of a case like the present one. Further, the instant case is not one where it is common ground that the additional item of property is liable to partition. The plaintiff claimed that item of property, so it's not relevant. I'll read further 14. It is for the defendants to pursue such action as they may be advised to get it declared that a disputed property is common property which has to be partitioned between them and the plaintiff. The only plea raised by the defendant all along so and so, so and so. If Lordship may further see the next judgment, which starts from page 150, and the relevant page is, if Lordship is page 150 itself. Lordship has that. This is Madras High Court judgment 1915 SAC online Madras 401. The only point argued before us is that in the suit out of which the present appeal arises, all the property of the deceased Sheikh Farid should be partitioned, and that therefore the first and second defendant, who are the appellants before us, should be given a share in the properties belonging to Sheikh Farid in the hands of the third defendant. This point was, however, not taken in the lower courts. What the appellant contended there was that the suit should be dismissed altogether on the ground that the plaintiff prayed for what has been referred to as partial partition. That expression, when applied to parties governed by Mohammedan law, is misleading. In the case of Muslims, what would be a partition suit if the parties were Hindus, ought often to take the form of a suit for administration of the estate of a deceased person. In the present case, the suit would undoubtedly have been better framed had if asked for the administration and had the appellant asked the lower court, as they now ask, the plaintiff's suit should be treated as such, and consequently one of the questions to be decided was what estate was left by the deceased. Our decision might have been different or based on different grounds. But in the state of circumstances with which we have to deal, we must only consider whether the suit as framed by the plaintiff was maintainable, whether the appellant's contention taken in second appeal for the first time ought to prevail, or whether the balance of convenience point against the appellants. With reference to the first point, it need only to be stated that under Mohammedan law, the estate of a deceased person devolves on his death on his heir, and each of heirs become entitled to a different fraction of every part of the estate. It is therefore futile to describe a suit in which one heir claims to revive his share of the property of the deceased from another heir as a suit for partial partition, and to say that therefore the suit is not maintainable. Both the terminology and the principles of Hindu law are in such a case inapplicable. This point must be kept distinct from the question that may arise when an heir claims his share of the property of the deceased, and when he really ought to institute a suit for administration, he asks for what is styled as partial partition. In such a case, it would be a question of the court whether in order to avoid multiplicity of suit, the plea of any defendants ought not to be given effect to, in order that the whole state of the disease should be administered, and in due administration should be partitioned for once. So the difference they have, the court has said that there is a difference between when you ask for your share and when you ask for the administration of the entire states. So in that you have to add any in order to avoid multiplicity of the suit, but the concept that one can ask for his share in one of the properties, and in that case it will not be in the mouth of the other side to argue that the suit is not maintainable because you have not added the other properties. It is free for them to pursue their case, or free for any of the legal heirs to pursue and get demarcated his share, which is already ascertained in any of the properties which I have not claimed in the present suit. Lordship may have that. And the last judgment, if Lordship starts from page 152, and Lordship, the relevant page portion is the same what I have just said. It is reiterated. If Lordship could have the last the inverted commas in para 2. The last line of para 2, in view of the decision of so and so, they refer the following question for the decision of full bench. Whether a co-sharer under the Mohammedan law suing to recover his share in a portion of his ancestral estate wrongfully inherited by another co-sharer to a stranger who is in possession is required to seek for partition of the whole estate, and if not, whether a suit for partition of the portion alienated is competent. The difficulty in deciding a question of this kind lies chiefly in the frequently which English judges have applied to suits between Muslims the rules that pertain to Hindu co-parceners. So and so observed, we see no reason for holding that the position of a Mohammedan plaintiff who claimed partial partition is any stronger than that of a Hindu plaintiff. And so wrote the following: the district judge refuses partition because this was not the suit for partition of joint family property as known to the Hindu law, but a suit by Muslims for their share of an inheritance. In this precedency, however, a suit for partition of an inheritance by Muslim is hardly distinguishable from partition suit by Hindu. With so and so, if Lordship may see para 5, in this view I am fortified by the remarks of so and so. In so and so judgment, the notion of joint family property and joint family business are utterly unknown to Mohammedan law. And by the observation of so and so, in so and so case, Mohammedans under their own law are never joined in state, whether they live together or whether they do not. But if there is no resemblance between law of Hindu joint family and the Muslim law, then try and decide the question of Muslim law in the light of the decision in suit between Hindu co-parson is not only to waste time but to risk error. I shall therefore confine my examination to these judgments which are not concerned joint Hindu so and so. If Lordship may turn to para 8. Their Lordship overruled the objection, remarking even as a rule of Hindu law is a rigid rule only as far as joint family property is concerned, being substantial rule of Hindu law. See so and so. If the property is not joint family property and the parties are not co-parcener but only co-owners or tenants in common, the rule is not so rigid and the partial partition may be allowed if there is not much inconvenience to the other sharers and if the plaintiff will be left without a remedy. So all these things are discussed. On the basis of these three judgments, it is very clear that partial partition, what is understood, is applicable under the Muslim law, that I can, out of the 4 properties or 2 properties, can ask the demarcation of my share in one of the properties. And it is not my case that I have to disclose about all the properties. Had it been that I want to have my shares in all the properties, and it is not anybody's case that I have stated that Abdul Ghani had only this property. Had it been a case that I have not disclosed and I have not come to the court with the clean hands, divorce this argument that I can go for the partition of only one of the properties, it is nobody's case that I have stated that Abdul Ghani has only this property. I am saying that my share in this property may be demarcated. I have 2/12 of my shares, each of the sons, and 1/12 of each of the daughters. So therefore, my shares may be demarcated, I may be given my share. Qua this property. So it cannot lie in anybody's mouth to say that either I have not approached the court with clean hands, or I have disclosed, my not disclosure of other properties will debar me from pursuing this suit. This is the point which I am trying to. So therefore, even Lordship takes that the plaintiff in their evidence have admitted, not admitted, disputed, made contradictory statement with respect to the fact that there are certain ancestral property in any part of India, whether it is Bihar or in any part of India or any other property. The issue today is not that on the basis of the admission of the plaintiffs in their evidences, the court will say that no, as you have other properties, therefore this suit will not be maintainable, could not be a ground. But I am saying that even the defendants would have taken this plea in the written statement, this would not have been sustainable in the eyes of law. That is the point I am saying. I am going a step forward. I am saying that had it been a case, the defendant takes this plea in the written statement saying that there are other properties, you cannot bifurcate the properties for the purpose of partition, and therefore you have to join all the properties. Only the Hindus in which they are co-partners have to join all the properties, and they have to bring all the properties in the hodgepodge for the purpose of partition and not the Mohammedans.
Kindly read para 18 of the judgment you have cited, the last one.
Para 18.
At page number 156.
What remedy is therefore open to me? I was inclined to think merely that he might ask for joint possession of the whole property, including the improperly hereded property. But I think that in the case of Mohammedans who owe their state before division as tenants in common, there is sufficient authority for the proposition that we may ask for separate partition of the state improperly hereded. This seems to follow from the authorized contract. A Mohammedan here is not a co-partner. He has not merely a right to be defined an immediate share in each portion of the state, but if any portion of the state is in any case marked off and divided from the rest of the state, he has a right to an immediate share of that
It
portion.
says that a Mohammedan can have multiple partitions for different properties.
But judgment says that on this they can immediately file a suit for partition
For boastful property.
for boastful property, which I cannot oppose.
In which you also would be a party.
I would be a party and I will be having my shares if any, and if I have sold it, I will be liable for redeeming them. That is not the point. Point today they have raised. It is not the question whether my grandfather had.
This I pointed out because it falls in your favor.
This is what I am trying to say.
This
So
is
they
not-
have all rights. I am not saying, and law does not say that if I do not add any properties, I will be barred from seeking partition of that property or demarcation of my share where also I am a tenant in common. So in Mohammedan law, there is no different concept. In Hindu law, the concept can be a co-sharer, co-owner, joint property, HUF property, but in Muslim law, the concept is one tenants in common. So it is not that in joint property, there is no concept of joint property that I will not touch this property, this is joint. I will touch this property, this is I am tenants in common. I am tenants in common in one, I am tenants in common in all. And I can seek my demarcation in one to the exclusion of other properties. Others can seek their demarcation in other properties. I can also be joined in that. I can, but if I file a suit for demarcation of that another property, and if I have not added this, the other laws which are basically will be applicable. Whether I will be barred, not barred, whether they can do is not the issue here. So therefore, Lordship, in the entire matter, out of the three issues which Lordships from yesterday till today, one has gone. Out of the two, the partial partition concept I have explained, Mullah says very clearly that you can go for partition of one property. In view of these three judgments, Lordship may again turn to page 5, which is very clear of this compilation, what the Mullah says. This is what I was trying to basically point out, that they would not get into this argument. It's a settled law. Page 5, again I'll just read for the sake of this Lordship only 4 lines. The doctrine of partial partition is applicable only to a Hindu co-partnership, where the co-partners are joint in state and not to Muslims, who are only tenants in common. Under the Mohammedan law, the heirs are deceased Muslims succeed to a definite fraction of every part of his estate. Muslim sharers are not obliged to sue for partition of all the properties in which they are interested. There is nothing to preclude one of them from seeking a partition of some of the items of the properties. It's very clear. And this judgment which is quoted there, I have quoted that judgment also. Apart from that, 2 other judgments which I have found. And this I have brought before the trial court also because they had tried to raise this issue. In fact, Lordship, this issue basically being raised is only to obscure the main issue which is central to the case is hiba, oral hiba. Lordship, may I just turn to, because I'll just finish on this oral hiba aspect, and if Lordship has any question on this partial partition, because I have quoted
I
Mullah.
just captured your argument. The learned counsel for the respondents, by referring to the issue of partial partition as raised by the learned counsel for the appellant, has submitted that partial partition is permissible under Mohammedan law qua one or the other property. He has referred to the book, namely Mullah's Principles of Mohammedan Law, 23rd edition, chapter 5, and in particular has referred to paragraph 43 and 44 to submit that it has been clearly mentioned therein that Muslim shares are not obliged to sue for partition for all the properties in which they are interested. There is nothing to preclude one of them from seeking a partition of some of the items of the properties. In support of the aforesaid submission, by referring to the authoritative text on Muslim law, namely Mullah's Principles of Mohammedan Law, the learned counsel has referred to following judgments.
12, 13 and 14.
Serial number 12, 13 and 14, paragraph number भी इसमें लिखा हुआ है.
Now the issue arises for consideration of this honorable court, which is central in fact to this particular case, is oral hiba. Lordship, all this survey, mutation and all that are consequent to that. That could be only corroborative, circumstantial, if they are able to first satisfy this honorable court that the ingredients of hiba is complete. If Lordship, in this context, the written statement was filed by defendant number 1, who is Dhoni, is very important fact, because my learned friend argued to the extent that as much time has lapsed, the witness might have died or much time has lapsed, so therefore pointing out a date, month, place becomes irrelevant or could have gone into oblivion. But Lordship may mark that it is defendant number 1 who has filed his written statement. And in the written statement filed on 12th of March 2015, after filing of the suit after a year, he has stated only the year and witnesses without naming the witnesses, without any date, without any place, and without any month. And Lordship, they have admitted on the very first argument which Lordship has asked them, and they have agreed on the point that all the 3 conditions has to go simultaneously. Means declaration, acceptance and possession. Possession could be constructive or actual. I have no doubt on that on the principles of law. So therefore, defendant number 1 was the best person because he happens to be the Dhoni. And he says if the argument of the other side is that all the 3 ingredients of hiba has to be done simultaneously, that itself shows the physical presence of defendant number 1 at the time of oral hiba.
That's their case also.
They don't say in so many words. They don't say in the written statement that it was done in the presence of defendant number 1. Where they have said so. They say that this is the condition or has been fulfilled. Where they have said that my father gifted this in my presence and in presence of so and so persons and other society के जानने माने व्यक्तियों के बीच में किया गया था. What they have picked up is from the book as to 3 ingredients, just basically copied down the three ingredients in the written statement, that there is a declaration, there is an acceptance, and there is a physical possession. But just writing this ingredient is not the fulfillment of the agreement, is the point. Because the best case they would have said that defendant number 1, Wali Alam, who has expired after filing of the written statement, was physically present at this place on this time when the father made the oral hiba in the presence of these persons. If the father did not know the name, how could the sons? Is an issue. And Lordship, very interestingly, if you Lordship may see the written statement of defendant number 1. Because there is an involvement of the sons of defendant number 1 in the written statement.
Let's see.
If Lordship could see.
Defendant number 1.
Written statement of defendant number 1, I found very interesting aspect in that. There are two written statements, one by defendant number 1 series, who are the sons, and one by defendant number 1. Lordship may see the written statement filed by defendant number 1 as to who has verified an affidavit. It's very, very important point which I have just seen yesterday.
His son.
Son. That is permissible under the law. Can be verified as long as you sign it. So therefore, at the time of filing of the written statement by defendant number 1, the involvement of son was there. So my point is something different. I am not taking today the objection of verification or affidavit. You get it verified, I don't mind. But you get it verified from your son. An affidavit by the son, one of the son who is one of the appellants here, and who became on record after the death of, whose that time he was not even a party. Kalimullah was not even a party at the time of filing of the written statement by defendant number 1. Because he could become...
Is it permissible under law?
Lordship, I tried to basically research on that. The law is flexible on that it could be verified on that. During the trial when I was trying to argue, I was trying to raise this issue. So I did not go into the details of that, but says that the law is flexible if Lordship could see the verification as per the CPC. To my mind, it is not permissible.
This person has been examined as a witness.
His brother has been examined. He did not
Kalimullah
come in.
has not been examined.
No. That is a very important point. And further, the written statement filed by the defendant number 1 series means the legal heirs is also verified an affidavit by this man, Kalimullah. Again,
And he does not
he
come
did
to
not
the
come to the witness
box.
No. So where the case stands. So they can raise any other objections of partial partition, non-joinder, misjoinder, but they don't go to the root of the case as to the hiba they want to avoid, because they are unable to prove it, plead and prove it. I'm not going even the proof, it is pleading even. That's very important aspect to it. How could Kalimullah...
You see, we have cases where the power of attorney can be examined
It is not
as
a case.
witness.
It is not
It is
a
not
case.
a case of power of attorney. In individual capacity, he is filing a written statement, and the person who is there is no explanation as to why he has not come.
And in fact, Lordship, see, before the written statement start, there is an affidavit, exclusive one, by this gentleman.
Yes, there is.
There is one page handwritten affidavit. If Lordship could
Prior
have.
to this.
Prior to this, in my certified copy, it is there. I hope Lordship must be there in the. Apart from the affidavit and this in the written statement, accompanying on the last page, there is a separate like this, Lordship, you could see like this.
No, it's not there.
It must be there somewhere because I have got the certified copy.
That's right.
And I'll just read this. What it says, I'll just during the lunchtime I'll point out the page also because I have seen.
It must be there, but anyways, you read it.
So it reads that I, Kalimullah, son of Wali Alam, age 44 years, by religion Muslim, by nationality Indian, resident of so and so, Jamshedpur, Simbhum, do hereby declare as follows: that I am son of defendant number 1 of the suit. that the statements made in the written statement are true to my knowledge, belief and information and 12th March 2015 at JSR. So what you depose and what you affidavit is the solemn truth before the court. So therefore, whatever you knew on that day, you put an affidavit. I'm not taking that plea of why he has verified and why he gave the affidavit. It is to my advantage that defendant number 1 in fact was not in the picture in the suit.
At least in the affidavit, he could have said that I have been instructed by
Not
defendant
at all.
number 1.
Not
and
at all.
These statements are
Not at
verified
all.
by defendant number 1.
He could only as attorney could have done so. But this helps me to demolish their case.
I've got that. 12.3.15. ऊपर में page number 1844.
Yes. I'm sorry. 1844.
Right? It is at running page 60.
60. So this is the one thing. Lordship may not see the written statement filed by the legal heirs. Written statement filed on behalf of the substituted defendant number 1 series.
Yes.
If Lordship could see in the pages, all the legal heirs of Wali Alam has signed this. All the legal heirs. Wali Alam had 4 sons. Wali Alam had daughters who had been served by this honorable court. All the legal heirs have Wali Alam have signed the written statement, and again the verification affidavit has been done by Kalimullah, who does not step in the witness box. And Lordship may mark that he was 44 years in 2016. So he was not even born in 1967. -2, it goes -2, -4. He was not born. Kalimullah, if Lordship may point out, as per the age he has disclosed in the appeal, as per the age he has disclosed in the affidavit, the age of Kalimullah will be -2. 2 years to be born. Kalimullah says that in the appeal he is 55 years. In 44 years he says, Lordship, take it, this is the best. 44 in 2016, 33 years plus 16 years comes to 48 years. He is 44, so -4. That means his date of birth is 1971. So the person who is born in 1971 deposes on an affidavit that I am son of the defendant number 1, in the written statement of defendant number 1 as well, and their own written statement, does not step in the witness box, who is not even born in 67, says, had audacity to say that this was done on the basis of oral hiba in 1967 in the presence of 3 witnesses. Will the court believe any inkling of believing this proposition of facts which are being put forward by the appellants? Is a question to be pondered. Why should the court believe in such a barred pleading when he was not even born? In 2016, he writes through his father that this hiba was done. So this argument that much time has elapsed, and also what we do, that in the case of probate, of proving a will, when we file a probate anywhere, we file the affidavits of the witnesses also along with the petition at times. That we never know that after 10 years
Who
of
signed their wakalatnama?
the wakalatnama, I need to see
This
that.
is also we
They're
need
very
to see.
interesting. Wakalatnama,
देखिए सर इसका वकालतनामा है
I doubt might have been signed by father, I don't know. The pages I can give, Lordship, where the wakalatnama is.
Yes, please.
The wakalatnama finds there in, Lordship, volume number 3, Lordship, it is in
You must have
volume
seen
4.
the, you must have seen the wakalatnama.
Yes, I have seen, but I don't exactly remember. During the lunch, Lordship, it is in volume 3, page 1 to 11. There are 11 sheets of wakalatnama. Volume 3, which I have written with pencil.
Yes, yes.
Roman volume 3, 1 to 11. I'm sorry that I don't remember exactly the point. I don't know whether Wali Alam.
What is the name of defendant number 1?
Wali Alam.
Waliya.
Well, there must be the first wakalatnama by the plaintiff. He is the defendant, must have filed later.
Yes.
So my learned senior friend was very emphatic in saying that one has to stand on its own legs. There is no legs here to stand. मैंने भी कोशिश perhaps किया था I could get it, but I again try during the lunch time to get to this root as to how things have I think Lordship, I'll check and I'll assist. I'll check during the lunch time. I'll check on that. Lordship, leave it that on this issue. So, as far as the pleadings are concerned of either defendant number 1 or the series of defendant number 1, the important facts is there is no date, there is no month, there is no place, and they only mention the witnesses without naming the witnesses. This is admitted facts. It is also admitted fact that it is nobody's case that any of the sons of defendant number 1 was witness to the Hiba. 2 sons goes into minus, 1 son of 19 years, 1 son of, I have noted down from all the records, the age of the son in 1967 will be Waliullah 19 years, Kalimullah -4, Amanullah 3 years, Sanamullah 6 years. These were the age of the 4 sons, 1967, as per their age disclosed in the appeal or in their respective affidavits, because only 2 sons came in the witness box. In the deposition for the first time, 2 witnesses, 2 sons of the defendant number 1 came to the witness box as DW1 and DW3, who is basically Waliullah and Sanaullah, who are the other 2 sons other than Kalimullah. Kalimullah did not appear. Even in the deposition in which they for the first time took the name of 3 witnesses to the oral hiba, again the date, month, place is conspicuous by its absence. It is not mentioned. DW2 does not again mention even the names. Who is the samdhi of one of the appellants? He does not mention even the names of 3 witnesses. What is more disturbing and pertinent to bring to the record of this honorable court is that all the 4 affidavits of evidence was not filed together. The evidence of affidavit of DW4, who is alleged to be son of one of the witnesses, was filed after the cross-examination of first 3 witnesses. So therefore, I could have understood that all 4s have filed together, and if all 4s would have filed together, 1, 2 and 3 must have known the name of DW4 also as witness. When they realize that by the deposition on 1, 2 and 3 they are unable to prove their case, they dropped in one witness saying that I am son of so and so. He was one of the witnesses. His name basically is DW4's name is, Lordship is his Naushad Ali, and he says that I am son of Gulzar. So he, for the first time, says that he was 16 years of age. If his age to be calculated from what is deposed in the evidence, he was 16 years of age, a minor, says that I was also with the father, my father, who is one of the witnesses. My father, Gulzar Ali, was one of the witnesses with the other two. I was also there. So he becomes a witness because they were not finding any witness till the deposition of 1, 2 and 3. So a parachuting of one witness was brought in who does not disclose whether his father was alive or not. They even trial court, they argued that you did not ask any, why should I? I said that this hiba was not done. Why should I get into this, that whether your father is there, why your father has not come? Why should I ask? You have to prove your case. Lordship may in this context have section 103 of the Evidence Act. What does it say? Section I'll just read, Lordship, for Lordship's consideration. 103 of the Evidence Act says that burden of proof as to a particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. If the law says that no, this fact will be disclosed by somebody else, if anybody wants the court to believe in existence of a particular fact, then burden lies on him to prove that fact. So whether they were able to discharge 103 is the point. Lordship could see, and that was pointed out also, D1, DW1, DW2, DW3 all disclose that their father are not alive. But DW4 does not say so. So it will be presumed that he is alive. It is not anybody's case that they have either all the three witnesses are dead or they are not traceable. It is not the case in law.
We cannot presume in law.
We cannot presume anything in law because in Lordship, in probate cases, if under section 63 and 67, two witnesses need to attest a will, one witness out of two may come to the court. If the witness has expired, the son of the witness or anybody who knows the witness could come and depose that yes, it is signature of my father who is the witness. The court, the party who is asking for probate can come to the court and say that these witnesses are not traceable or dead. Then only the other person can come and depose. That is the law. It is not that in the presence of...
The principle is that the best witness is required to be produced.
I am saying the worst case.
Particularly a person who is a witness to a oral transaction. And he does not say late.
Doesn't say so. Father might not be agreeing for this false case. I don't want to depose falsely in my fag end of my life. It could be a reason. A pious person, irrespective of religion, will never come to the court of law and say that I will depose something false. तुम लोग खुद देख लो, हम नहीं जा करते. Could be any reason. It is full of speculations. But the fact of the matter that none of the three witnesses who were not named later, came to the dock of the court to depose regarding the hiba. That is the point. If Lordship further see,
Let me just complete on.
I'm so sorry.
The learned counsel for the respondents has referred to the written statement filed by DW1 and has submitted that the written statement was verified and affidavitted by his son,
One of his sons.
by one of his sons, namely Kalimullah, disclosing his age as 44 years as on 12th of March 2015, meaning thereby in the year 1967, he was not even born. The learned counsel has submitted that there is no material on record to show that the reason as to why the defendant number one himself did not verify the written statement
Or file
filed by
any
him.
affidavit.
He has further submitted that the written statement was accompanied with an affidavit dated 12/3/2015, again by Kalimullah, which also does not disclose that the statements in the written statement filed by on behalf of defendant number one was at the instance of defendant number 1 or at the instructions of defendant number 1.
Or as an attorney of defendant.
Or as attorney of defendant number 1. The learned counsel has submitted that during the pendency of the suit, defendant number 1 expired
After the written statement was filed.
after the written statement was filed, and the written statement of substituted defendants was
Who were the
also
legal heirs of
filed,
defendant number
who were the legal heirs of defendant number 1 was also filed, which was again under the verification and affidavit of Kalimullah, one of the sons of defendant number 1. He has submitted that Kalimullah at any stage did not depose before the court. The learned counsel has further submitted that so far as the initial written statement of defendant number 1 is concerned, he being the alleged donee with respect to the suit property has simply mentioned in the it has only been mentioned in the written statement that in the year 1967 the property was orally gifted to defendant number 1 in presence of witnesses. But he has not mentioned the name of the witnesses nor the time, place and date of oral evidence has been mentioned. The learned counsel has submitted that defendant number 1 was the best person to disclose the foundational detail in connection with the hiba. He has further submitted that even in the written statement filed by the legal heirs, no such detail was mentioned. The learned counsel has further referred to the evidences led on behalf of the defendants and has submitted that the defendant number 4 had given the name of 3 witnesses for the first time, and one of those witnesses was his father. But at no point of time but there is no reason as to why any of the witnesses, including his father, were not examined before the court.
And further, Lordship, the D1 to D3 did not name this DW.
The learned counsel has also submitted that the witnesses D1 to D3 did not even name that D4 was present at the time of hiba. The learned counsel has submitted that the evidence of D4 reveals that his father was alive, inasmuch as in the evidence on affidavit he has not mentioned before the name of his father as late, and
All other 3 witnesses state so.
sorry.
All other 3 witnesses state the state of father that they are late.
Okay,
2
but all the other 3 witnesses have specifically stated about the
demise of their father.
demise of their father.
But there is one more argument what I am trying to say. In paragraph 26 and 27 of the written statement, they say that hiba was done by my father in the presence of the witnesses and accepted by me, possession given. My learned friend had argued that all these things has to be done simultaneously. It is not a word anywhere that Dhoni was there. It is not a word.
The learned counsel has also submitted that the appellant have themselves during the course of argument have stated that all the 3 ingredients of hiba, that is
Declaration, acceptance and possession have
has to
to
be
be
done simultaneously. But in the entire written statement, the presence of defendant number 1 at the time of so-called hiba has not been mentioned. Can continue in the second.
Yes.
How much time?
I will
more time?
45 minutes. I'll conclude this. If Lordship starts at 2:30, I'll conclude within 45 minutes. Because that is the point. There are 3-4 points on the judgment.
I'll come back at 2:30.
Much obliged for the patient here.